Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Is that correct?
I didn't ask you to interrupt me.
Literally not true.
Oh, for Trump's sake.
Good morning, good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. It is Thursday, a podcast Thursday as well. Super excited to be here today and tonight. All right, I think we're ready. So far, so good. I don't need that. I don't need a topographic map up here for right now. I just need a tally. Oh, would you look at that? Sloth Life, who had originally won the internet, has kindly offered the internet to Bora Bora. Bora Bora, this is your first. This is your first time. It doesn't matter if it was gifted to you or if you won it organically. The punishment is the same. You are, in fact, the winner of the internet. All things IP-related are now your problem. It's pretty much just a problem. I wish I could give you more, but no, it's just the problems that come your way. So apparently you wanted it, or you didn't know what you were asking. So that happened. Why am I so blurry? There we go. A little less so. Bora Bora, congratulations. You are the internet winner. And I guess this goes on your permanent record, just for you to know. I mean, I'm not sure if that's a good thing, but it is what it is. All right, why does it feel so light? Like there's too much light in here. Maybe my eyes are just sensitive. Blurry and stuffy. Not quite as stuffy as before, so I probably should sing before it, gets all stuffed up. So this is the only way I'll win the internet. Someone please gift me with it, says Kelly H. Your refresh game is not on point, Kelly. Okay, I have made another mug of steaming hot Stevens hot cocoa. After first confessing to my wife that I drank all the existing hot chocolate and then put the empty container back in the bin. I made another one, but I used the tea kettle, the electric tea kettle, to heat up the water, and I neglected to take it off when it was just the right temperature, and instead I mixed it when it was boiling. So now my question is this: with these Stanley mugs, how many hours do you have to wait before it's possible to sip it without scalding your lips off? If somebody could just give me just like the rough, I mean, is it sometime tomorrow or what? Take the lid off. If I take the lid off, it will dump all over my 17 hours. Oh, good. So tomorrow, just wait forever. My laptop, yes, a very long time, 6 to 8. Okay, the lid has to come off then. I need to drink this. 20 minutes, Holly. What's your mouth made out of? Granite? How could you, wow, ice cube it? I don't have any ice cubes. Chat, it's not on screen. Oh, bing. Thank you. Oh, it's so hot. Let's put it this way. I thought maybe it would be cooler if I, thinking back to my days when I listened a little bit in physics and science classes. Heat rises, right? So if I put a straw in, I'd be drinking from the bottom where it's colder. Thinking, using the brain. So I tried that, and I think I've got blisters in my mouth. It was not colder at the bottom. I think what happened was I put the straw in and the hot water entered the straw immediately, and I just drank that first. So, all right. Yeah, straw is not. And now the straw, which is a heavy-duty plastic, like reusable plastic, is now S-shaped because it curved. It melted. It melted in the lava is what happened. And then the lava went in my mouth. So soon I hope to be able to sip from this. Put ice in it. I could probably make ice, like put ice cube tray in the freezer, make ice, put it in there before it gets cold enough to drink. All right. Final call for birthdays. We only have one on the list so far. Please join. You get a stuffed up Scott singing happy birthday. I mean, how many people get that? Just yesterday's and today's. I coached gymnastics and Stanley's were out of control. One girl even stole another girl's. It's madness. Oh, there's some that are like the ones to have. It sounded worse for the wear. Woke up with a headache. That was great. So it's good to be here. But let me tell you, I am actually super excited about today. For a couple reasons. First of all, this is the last big battle. This is the last, fight it out in front of the judge moment we get in this trial. And I think both sides are going to give it their all. In the past, they've made an argument, the judge has ruled, and it's been okay. We've seen now from AJ that they make an argument, the judge rules, and AJ now argues again. I think we're going to see that if something doesn't go his way. I think he's going to push hard. Oh, my goodness. Craft yourselves. 29 months. 29 months. Wow. That is absolutely amazing. Thank you for your long-term support. Original OG on the channel. Awesome. Shells, thank you very much. All right, it could get spicy. It's going to be spicy. It's Kai's birthday today. Remember, he's 10. I thought it was today. I thought that was yesterday. Didn't he say it was yesterday? Hannah, welcome to the gallery. Thank you very much for your continued support as well. Great to have you here. 29 months. Shells, that's amazing. Hannah, I don't know how many months, but we've got an orange courthouse, so I think you're over the year mark. Kai was yesterday. Kai was the witness's son, who he did a shout out. It's like, happy birthday, Kai, on the record. And the judge struck it. So, zero fun, judge. I thought he said almost. Bought a 40-ounce tumbler from Hobby Lobby. It's the best one I've ever used. Gave away all of my leaky Stanleys. I need one. Is Hobby Lobby the place to get them? Because some of them, Stanleys are spendy, right? For some reason, Stanley used to be like the stamp of the working man, right? He'd have a Stanley thermos that he'd take in his lunchbox to the construction site. And it was function. It just worked well. That was it. And now it's become fashion. And the price is just up through the roof. Love them, but I just need one that keeps my water cold. It doesn't have to look good. I could care less. It could be pink with unicorns. If it just works, I'll use it. But is Hobby Lobby the place to go? Let's see. Owala is the best tumbler. Hydro flask cups. I need a big one that keeps it cold. So 40 ounces, 60 ounces. I don't know. I'm not really worried about weight because it all just goes on the bike, and the bike will just handle it. Check Home Depot and Ace. My closest Home Depot is over an hour away. Okay. All right. Ello. They have a ton of styles. Keeps cold. Affordable. Good stuff. All right, we are collecting birthdays right now. We're not stalling, but if you have a birthday to be reported, now's the time to report it, because once the music starts, that is not the time to report it. That's after the time to report it. So, Rebecca, thank you very much. I thought we did celebrate yesterday when you made 29 months yesterday, right? I thought we celebrated. It was amazing. Nobody has gone beyond 29 months. That is the most. And Rebecca, you're one of the OGs that way. Yeti at Dick's. Yetis are expensive, aren't they? I thought they were right up there with with Stanley. $48 ounces, cold all day. I don't need all day cold because I will drink 48 ounces before the day is over. 2 at Walmart to keep ice frozen in it for 2 days. All right, there we go. Okay, so I've got some places to shop. Father's Day, for Father's Day, I'm going to Ace Hardware, Hobby Lobby, and Walmart. Need Father's Day gift ideas. Do I have an idea for you? Hang on. Stop. First of all, is the father in your life, does he like, are you looking for something he's never had before, probably never seen, and will think is cool? If the answers are yes, I have something for you. Aaron Blackman, huge super chat, says, sending the positive vibes as I'm starting a 32-day vacation. You couldn't make it 31. It had to be over a month, right? Thanks for the great coverage, RA. I was not guilty until I heard Aperture, then went guilty. Now I'm not guilty again after Dr. L and the new ARCA doctor. He's been flip-flopping back and forth as the evidence comes in. I love that you kept yourself flexible and listened to the evidence. That is great. Thank you, Aaron. Take us with you. 32 days. You bring a friend, right? Sharkey is already sneaking in your suitcase. That spot is filled, I guess. Going back to the Father's Day gift. This is this is pretty unique. If I can type, it would work better, but apparently I can't type. Let's try that again. All right. Trying to find the one that has the best price for you. Here we go. Has Prime and everything. All right. I just put a Father's Day gift idea in chat. It is an Amazon affiliate link, and it goes to a very unique item. It's a Tesla coil speaker, which shoots electricity into the air. It's insane. It's absolutely wild. They're the coolest thing you never need. I mean, it serves no legitimate purpose. You can like light up light bulbs in your hand with it. You can make sparks and touch them, and it's cool. Does nothing useful. But yeah, it's really cool. Brandy is here. Brandy, welcome. We loved the stats you were given yesterday, Brandy. By the way, of the objections and sustainings, and I think, though, I'm not sure. I don't mean to question your math in front of you here when you're not here, able to defend yourself verbally. But I think the 35 number was a little high. It seemed high to me. 35% of defense being sustained. That seemed like you had maybe inflated it a few to make it look better for the judge. It was. Oh my goodness! Wow, what a day! It's going to be crazy today. It's going to be crazy. This is the last, and we've got the fan. The fan is ready, by the way. It's going to be crazy because this is the last day for the two sides to fight out anything. If there's something to fight over and the judge has to decide, it gets fought out today. There's very little. There'll be some objections of sustaining, and remember, closings are not testimony and things like that. We'll get some of that in the closing, but this is really the last of the big spice until the closing argument, which is where it all goes in the mix. It all goes in, and it's just going to be wild. My math is not math. No, it was probably right. I'm just joking that it felt like less than 35% of the defense's objections were sustained. So I would never question anything that came from a Churchwell chart. They're absolutely amazing. Greeners says, I think today is officially a no sidebar day. Okay, we did the math on this one, Brandy. Yesterday and the day before, we compared because the day before yesterday was a no sidebar day. Remember, the judge said, now, jurors, in order to speed things up, we're going to have no sidebars today. And then we had 14 of them. And then yesterday was just a regular sidebar day, which also has 14, just for the record. They are the same. It's sidebar days and not sidebar days. It's just the no sidebar days, I guess it doesn't count against you. So that was really interesting. Hank is not calling any rebuttal witnesses. Wow! Do you know why? Because he had to neuter his expert in order to get anywhere with Mr. Rentschler. He had to base the question on the assumption that Mr. Rentschler was completely wrong and baseless, in order to say then in that case, then the work you did based off his work would be wrong too, right? You can't bring that guy in. And then knowing full well that what's going to happen as soon as defense gets up there, they're going to be like, hey, Dr. Rentschler, I got 3 pictures for you. I'm not sure if you've heard about this. It's a technology called X-ray. Remember the thing you said did not happen? They're right here. Can you take a look at these for me? Yeah, it would just be wild. It would be wild. And so, yeah, anyway, I'm excited. I'm excited for closings. Honestly, I'm excited for this case to be done. I think everybody, family, the judge, the prosecution, defense, Karen Reed, everybody has been dragged through this process too long, and it needs to come to a conclusion. All right. We have one birthday. Josh, thank you. A reminder for the second buffer. All right, here's what we're going to do. We're going to sing Happy Birthday with my, stuffed up nose. And so I need you guys to sing loud to cover my voice so that nobody hears me. You should hear yourself clearly and maybe a little of me in the background. That's the proper volume to sing at, whether you're at work
birthday.
or at home.
You look good.
Judge Fleischer, thanks for weighing in. Appreciate you coming in this morning. Thank you, Judge. Wherever you are, in the car, windows down, mowing the lawn with the headphones, doesn't matter. I do ask and expect all of you to sing and help celebrate Jane's birthday, just like we celebrated Kai's yesterday. So, do I have an understudy? I probably should. Are you applying, readers? That would be awesome. All right, so here's what we're going to do. Everyone stand up, take a deep breath, put your shoulders back, project your voice to the back of the room, blend your voice with your neighbors, warm up with me, if you will. La 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 la. There we go. We're all in tune. Add Ashton to the list. Okay, it's going to be Jane and Ashton. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Jane and Ashton. Happy birthday to you. There we go. Jane and Ashton, happy birthday. There are many wonderful birthdays. There are many wonderful days. Today is your birthday, which makes it wonderful for you. I realize there are a million places you could be, a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor, the joy is ours. Hopefully we can return that joy back to you, make your day a little more special, or begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, and Bob Evans. Did I say McDonald's twice? I would only go there once. You don't want to push your luck, really. Not a sponsor, by the way. You don't want to push your luck at some of those restaurants. There's a good chance you go there once and then you can't go there for a couple days until you recover. I'm not saying McDonald's is the one. Happened to be at Waffle House, but this is all about my base. Happy birthday. Thank you very much for celebrating with us, letting us sing to you. It's our pleasure, Jane and Ashton. Hopefully, see, I'm decorating the house for my daughter's 14th birthday party this weekend, says Tisha Sidebar. Let's see, we've got the dancers going. Great job. We're going to listen to the rest of the song. Remember, there's an air drum solo, which all of you are also contractually required to participate in right at the end. So listen for that. I might move my mug just a little bit further out of the way in case I get a little energetic with the air drums. Happy birthday to you. Linda Ann, what's her name? Happy birthday to you. Happy birthday, Linda Ann's daughter. Happy birthday to you. Oh, I missed it. Guys, I hope you didn't. I was busy singing to Linda Ann, who came in a little bit late, I might say, a little bit late. But it looks like many of you did nail the drum solo at the end, so it's all good. It's all good. I do sound sick. I feel better. I'm not dead yet. Let's put it that way. That's my level. I'm not dead yet, but I've got just a wee bit. I miss Thal and his tackle hugs. We've talked on the phone a little bit. He's a busy guy, and he's got some things going on, but we've talked a little bit. He'll be around. He pops up. He's like a bad penny that way. He always turns up. But Kim, thank you for the super chat. Thanks for your support. Okay, let me move the mug and bring in the only fan. Remember, just a reminder, we do not have the jury today. The jury gets a day off. So they will be back on Friday. Friday we will get the closings, jury instructions. I'm not sure which order that's going to be in. Sometimes it's jury instructions, closing, jury instruction, charge, or jury charge. Just depends on the judge's preference. But generally, we're going to get closings, and that's going to be usually, I don't remember from last trial, it goes state, defense, state again, because they got 2 bites of the apple. It's the same amount of time, they just bifurcate it, which allows them to respond to the defense portion. But I think that's what's going to happen. It's going to be good. An hour and 15 minutes each is what we expect the judge to allow on closings. An hour just isn't enough on a 30-day trial. I think you need more than that. If Karen's found guilty, she will be able to stay out on bond while her case is on appeal, or will she have to go to jail? That's a judge's decision. Things in her favor. She's been out this whole time. She hasn't been in jail this whole time. She's out on bond the whole time. She's good behavior throughout. So why needs to happen? Amber sent you the soundbite. I'm waiting. Okay. She did. I have it. I think I even.
Gross.
Oh, that's the wrong one. I've got it somewhere. It's on my phone. Why and gross needs to happen. We'll make them for you. All right. Let's see. We have not done a poll. Honey, thanks for bringing this up. We did not do a poll because they arrested right at the end of the day. I usually wait, well, by tradition, we wait till the end of the guilt phase as far as testimony goes to do a poll. So it is time to do a poll. That is something that would be appropriate today. And I'm going to go ahead and put that in there. There will be at least 3 options, right? So give me a second to build the poll while we watch the OnlyFan. Spelling is kicking my butt this morning.
I'm not a cat.
Let's see. Almost done. Almost done. Trying to get these perfect. Okay, there we go. Poll is up. We have 4 options. Please read them carefully before you vote. Where do you stand on the Karen Reed
Nothing
case?
in the order that restrains you from talking to cats.
Options are as follows. Let me read them for you. Option number 1, I think she is factually innocent. Number 2, she may be guilty, but wasn't proven. Number 3, she is guilty of murder 2. That's the intentional one. Or number 4, she is guilty of manslaughter, which is unintentional. So, for those who are calculating the math on this poll, 1 and 2 equate to a not guilty verdict. 3 and 4 would be a guilty verdict of some sort.
I was told counsel wanted to see me at sidebar.
Let's see. I was on. Who said spicy?
I'm not going to argue about semantics here.
Honey's mom says, by the way, can you find my doctor excuse in your email for me being out yesterday? Yeah, we added it to your file. I did question the handwriting. Looked a little neat for the doctor's signature. Sounds like you also have a sunburn, so I'm just curious. Miss Joni Hockey, I was on Rewatch Crew yesterday, and all I can say is it was spicy. It's been amping up the whole time, and I think it won't stop. Today is going to be nothing different, especially because they're not in front of the jury. It's gloves off right now. This is the last, go for the jugular.
In front of the Walmart.
We all know the defense is done, but they haven't officially rested in front of the jurors. Kayla's diaries, I think they did.
In the order that restrains you from talking to cats.
We had Sue O'Connell tweet out yesterday that confirmed that the defense had rested. It was a conditional arrest. They might do a more formal one, but they went back to Mr. Jackson and said, conditional upon this, the defense rests.
I'm not going to argue about semantics here.
So Karen Reed, we knew Karen Reed was not going to testify in this trial, but that was confirmed a couple days ago as well. Heard Karen Reed commenting about needing to keep a close eye on the jury charge. What happened to the first trial with that? I think the bigger issue in the jury charge is where the law is basically given to the jury, right? They say in Massachusetts it's against the law to do X, Y, Z, and they typically only list the things that are applicable to this case. And the various charges, right? The lesser included. You've got murder 2 and a lesser included of manslaughter, but they charge for both. There might be some other lesser includeds, like grievous bodily harm or something. I don't know. We'll see. But that's all going to be spelled out in the jury instructions of the jury charge. The charge itself is go forth and reach a verdict, right? That's the charge. And the instructions are that this is how you reach your verdict. And the important part of the instructions on the tail end is here are your verdict forms, and this is how you should fill it out based on your verdict. That part we need to be careful of. I really hope the judge does not pull a, I liked how he had it last time, trick. Last time it was confusing. Last time it was objected to. They tried to change it. She wouldn't, and there was a problem. Let's fix it this time. Let's get it right.
Squirrel.
Let's see. Is not guilty on the jury form. Yes, it is. It is an option. It has to be on there. I was only joking the other week when I'm like, jurors, you may have noticed I've been working on some paperwork during the last witness's testimony. That's just to save you some time. I've just been filling out the verdict form for you. No, I was just joking about that. The verdict form should be blank. It should have all the available options on there. Hopefully it's just clear and easy to understand. That's what we want. The process of how you reach different verdicts needs to be clear. All right. That must be the most famous fan by now. It's the only one. I think it even has a website. I heard there's a website for it. Just kidding. That's a joke. Don't go there. Don't go there. All right. Celine Dion.
Bring the jury.
Mr. Yanetti's a Massachusetts lawyer, said he never saw a jury form like last one. The judge says that this is how she normally does it. I've heard the rumor that she's retiring after this trial. That would be awesome. I'm a big fan of people retiring. It's the goal in life, really. You know, make your money and retire. Live happily ever after. I hope she does. From all accounts, the jury is smart and has paid attention, so I think they'll get it right this time. We did have some questions about what does strike it mean, but I think that was interpreted wrongly by the judge. I think the question was more specifically, what are you striking, not what does strike it mean. She'll open a bar named Side Bar. I'll see you at the Side Bar. Please come. I'm ordering you to come to the Side Bar. How did the OnlyFans joke miss me? We've got a song about OnlyFans. Grandpa's OnlyFans. You should create an ooh gross soundbite. I don't have the full ooh gross yet, I don't think. I've only got the why. Who do you think she is calling when she has a problem? I believe a lot of judges will consult their preferred method, whether it's law books, Google. I don't know what it is, but they'll do research when they go back in their room. Very few of them are probably just like, I need it silent so I can meditate and craft this in my head perfectly. Most of them I'm pretty sure I had a case like this a couple months ago. Let me just check my notes and see if I can copy and paste the answer. That's what most of them are doing. I want defense to ask to see the final version of the instructions and verdict form. I think they're going to see those for sure. Eileen, it's retirement at Christmas, the 24th of 2025. That is awesome. But who's counting, right? Who's counting down? That is so cool. Only problem I have is no complete investigation inside the Albert House. That part was kept out of this trial very, very effectively by the prosecution and the judge who tag teamed that one. You ever see the clip I sent you via Burner about her talking into her hand? I've seen it. I saw a couple of people sent me that one. A couple of people sent me the notes that she was passing back and forth to Tori, which she does quite often, those Post-it notes. They've talked about no investigation. Pictures inside the house, pictures inside the garage did not come in. We heard very little about Chloe. The ballot, the poll is still open right now, so please vote when you got a chance. We're going to close it here in just a minute. My real question is, how would the fan vote? It's the silent observer on the ceiling.
You are unmuted.
It's time. We're going to close the poll out right now. Check chat for the results.
Was now open. You may be seated.
Good morning, Your Honor. May I call the case?
Please.
For the record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Your Honor. Laura McLaughlin.
Good morning, Ms. McLaughlin.
Adam Malik for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right, so first thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification, and your rights are saved on that. So we ready to go forward with the charge conference?
We have trampled on your rights, but they have been saved.
I guess I have a question first as to whether the court would like to entertain the argument on the motion for the party finding not guilty of all the evidence.
So, no, we can do that now. So now that my ruling is on this, Evidence is closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
This is where the spice starts right here. The street Eddie's going to bring it.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these 3 indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death. A dog which mysteriously was absent from the home at 6:30 in the morning on January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept. A dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesado, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sallyport, the taillight was merely cracked. When he was shown photos of what it looked like in the Sallyport after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Albert who is on video, hot, angry.
Brian Higgins. You just said Albert. You mean Higgins, right?
I meant Higgins, yes. Yeah, the same Brian Higgins, who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Albert's residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all three indictments.
Mr. Brandon gets to argue opposite. This will be denied, by the way. Sorry, didn't mean to spoil that for you. Oh, Mr. Lally. What, if anything, do you have to say?
Thank you, Your Honor. The Commonwealth would request that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there. The
Chloe doesn't exist, guys. Chloe
arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples when it came to Officer Barros. His testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally Port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. La Posada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the cruiser camera video, drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standard in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
So, Mr. Yannetti, you know I have to view this in the light most favorable to the Commonwealth.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied.
Thank you, Your Honor.
Okay. All right. So regarding the charge, so we'll start with the defendant's missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw 2 of our requested instructions, which would shorten things today, I think. So,
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction, you're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that request.
Okay, I had a question about that. All right, thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right. You filed. I saw it in email. I don't have a hard copy of it.
That's Mr. Alessi's.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it. Okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're going to go through them one at a time. Who's arguing for the Commonwealth?
I am.
Okay, so I think you're sort of in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions, and just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand the court's position might be on this, but as far as the instruction related to murder charge, the Commonwealth is only seeking an instruction on murder problem.
All right, so we will deal with that. I'm going to go through the defendant's instructions, or sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably... Okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though I think it was, and I was upheld on it, so I will make it crystal clear. Okay?
That's what we're looking for.
So I'll give you that, Ms. Giannetti. This what is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So, Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor. When it comes to the Bowden, and I would incorporate, and I know there's no request for instruction for third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden? You don't think the Commonwealth, the defense should be allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third-party culprit in this trial has come from questions from the defense counsel, not from actual evidence in the case, not from testimony from witnesses from the stand, exhibits that were put into evidence, or anything of the like. So in the instruction and the arguments are based or predicated in the case law on evidence. And obviously, as the court is well aware, there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is that the court looks at what is actually in evidence in this case. There is no basis whatsoever for not only a Bowden or a third-party culprit instruction, but specifically for even counsel to make that argument during the course of the closing. And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Ms. Giannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate materials, active evidence. Chain of custody was contaminated and corrupted. There was evidence of the bias of the lead investigator, failure to pursue other suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lally comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to do it, we were prohibited.
I think what Mr. Lally was saying, that you asked questions but weren't given answers. And so I think that's what was said. I'm going to, Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know. But tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did it.
Okay, so just so that it's clear, you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. Correct. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay? Okay.
And that's really what I was seeking, just clarification based on
Yeah. So Mr. Yannetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give. Sure, go ahead.
While we're on page 8, I just wanted to, Alma does have an objection to the DG instruction that's at the top of page 8.
Yeah, I have a check mark next to that. Ms. Giannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously it's not the strongest DG Batista argument that we would have. It did not occur at a police station. But, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on their own cell phone. It could have been done. It wasn't done. We had to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So we still think we're entitled to leave.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who refused to sit down in the living room. They were surrounding her. Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr. Hill?
And I would also add, Your Honor,
sure.
They did seize her vehicle at around the same time. So, that it goes to, I think, the issue of custody and my client being able to deny it.
All right. What do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the trooper spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, throughout the course of that day. They spoke to her while she was seated on the couch in her parents' living room, with her parents present. No one was restricted from being, and it did not end in any sort of custodial situation. She was taken into custody. She wasn't arrested. Yes, they did seize her cell phone and her vehicle based on information that they developed throughout the course of the day and from statements from Ms. Reed herself. But I don't think that transforms that conversation or interview in her parents' living room into a custodial interrogation. The bigger issue that I have is placement, as far as there's already been within the same request for jury instructions or request for humane practice, and then following the DEG and Batista language in the defendant's request for jury instructions, there goes on to all of this other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of humane practice. I don't think it's something that should be highlighted in two different sections. And I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and have his testimony from the stand, that initially she said she wanted to be fine with answering questions, but they wanted to get into many details. And then when the questions became centered on, or more centered on details, at that point, and I know that's not evidence to the jury, but of course, well aware, she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview, and I don't think that arises to the level of the DEG instruction. So I would ask basically that everything on page 8 prior to the vote instruction be excised.
All right. I'll take another look at this and I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at the residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not
yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn. So is the...
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view was not present on January 29th. We asked the court to repeat that one sentence.
Okay. So I did not see this when I took a quick look at the view. All right. I'm not going to repeat it. All right. Lost or destroyed evidence you're withdrawing.
Yes.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just in reference to that.
Sure.
Only language in there that I would object to.
Okay.
Testimony of a police officer or someone else who works for a law enforcement agency.
What do you mean by that?
I think that was taking into account the dispatcher, perhaps. We're not.
I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that might be correct.
Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give. I'll cover all those topics. What page you on?
16.
Okay.
One suggestion there was indicates now the Commonwealth has introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think the defense has introduced more graphic.
Yeah, so I would just say you've seen photographs. Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally, so let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon.
Yes.
All right, so I'm going to give that, Ms. Gianetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence, evaluating the evidence, there's some instruction. Ms. Gianetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
We're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Aruba, Jamaica. Ooh, I want to take it.
Your Honor, with regard to Aruba, we don't believe that there was really any that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay. All right, so did I give it any other time that there's another event that I should highlight? I don't think so.
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So
we would object to the part of that act being linked to the Higgins text message.
all right, I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt.
You're on call.
Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
No, so the only...
1 second, let me just pull that up. Okay.
Your Honor, the request is merely not for any change or alteration in the instructions that were given, other than there are three prongs of malice, and essentially the Commonwealth is requesting is that the jury be instructed.
Speak up.
Merely on third prong malice, because that's the only one that really applies to these factors.
Okay.
The Commonwealth here, the first two prongs are essentially extraneous in this situation, and you don't need to see explanation.
Can't hear Lally over the mumbling of the court reporter.
Do you have supportive case law for me to single this out?
I do.
What do you say, Ms. Giannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm, not intended to kill him. And it was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we'll defer to the court on this.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon.
I will endeavor to do so, Your Honor. We will. I don't have anything.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
And that's really the only reason for this. But I understand, and I don't certainly want to take.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply, maybe.
I wouldn't mind.
We wouldn't have an objection to that.
Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs.
That means you can ignore some of these instructions
before you begin.
You can choose which ones.
All right.
And Your Honor, before the court makes a decision on that, we see what the court is proposing. If you are going to alter the panel.
If I alter it, it means I remove those two. That's all.
Right, no, we just want to.
Yeah, sure. My guess is that won't happen, but we can see. All right. So, lesser included offenses. Did you want an OUI instruction? We're
asking for that.
Okay. All right. Right, I think that's it, aside from Mr. Alessi's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages. We have a redacted version now, which we'd like to submit to the court of the copy to the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's ruling.
Okay.
But it wasn't in final form. We believe it's in final form now.
And you all agree that it's in final form?
Well, they haven't seen it. But I'm going to give it to them now. Can I hand this to the court?
Sure. Thank you. All right, so
the only other issue, Your Honor, is we do have
hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it. So
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
Okay.
Just a couple other things before we get to Mr. Alessi.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced to the evidence, Your Honor.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't.
We had to redact it, so we redacted. It's on a thumb drive.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Blally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count 2, Your Honor, if I didn't.
You did not.
Okay. We do have one. We've got given a copy to the Commonwealth. Can I hand the proposed copy to the court?
Sure. Is it the same as last year's, but now with a...
It's different.
Okay.
I don't think she's going to go with theirs. I think she likes hers.
All right. Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually Yannetti.
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser included and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
The analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least, looks like three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clearer, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the Court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if the evidence supports it, the defense requests it, that the Court must give it. Having said that, the verdict slip that was used in this matter last year, the Commonwealth would submit is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the Court's attention, I don't know if Your Honor is aware, there was a case recently, while this case was going on, tried before Judge Olau, in which he had similar issues and I believe used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in that case. I don't have a copy of it on me, but I can certainly get the Court a copy with it. But that may be somewhat helpful if the Court is thinking about it.
Okay, was that on a murder case?
It was not, but it had to do with a felony motor vehicle homicide.
Okay. Yeah, I'll take a look at it.
Mr. Turk. Mr. Turk.
Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lau is an excellent judge. We think that this verdict slip it provides the most clarity for the jury. That's why we're
okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right. So, Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering. Okay.
Do you need an extra copy, please?
Sure. Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
It's LLLL for ID.
Thank you. Mr. Lally.
Your Honor, just one request circling back to the constitutional instructions. So Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference in this argument to the jury related to specific areas which we would need judicial approval before we did. So the two areas that are sort of listed within that we would like to make some argument to the jury regarding is the defendant's taking of the Lexus from one metal that came to her parents' residence in Ayden, and then certain statements made in reference from the various clips that were played of her statements.
Okay.
In particular, would be the one where essentially she says that it came to her.
Okay.
The exact.
I can't
All
hear
right.
Lally.
Mr. Yannetti, do you want to weigh in on that?
Yes, we object to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other clues.
Yes, so I did want to ask you, though, Ms. Giannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No, we
Okay. Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Giannetti? We're going to hear from Mr. Alessi, but...
The Commonwealth does not object to the redaction.
That's great. Thank you. One less thing you all have to do today. Okay?
This is Mr. Alessi.
I know. All right, so let's make that... Are we switching that new redacted version with an exhibit number? Do we know what it was before? Excuse me. The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
This is the testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just... 209, is everybody in agreement that it's exhibit 209?
Yes, sir.
Okay.
Does the court have a copy or do they need the Commonwealth?
No, I wrote on it. I need the Commonwealths.
So this is a clean copy.
So that will now be 209 in evidence. You know what? Can we make that 209A? We need, Ms. Giannetti, we need to keep record of the first one that was not redacted. So any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes
What do you think? Yeah.
It should become ID.
Yeah, so we'll switch it back to ID, and this will just be 209. All right, did we have an ID number on it originally?
NNN.
Can it still be that?
Is it redacted, the NNN? Or is it, no, it can say that.
Okay.
Right?
Oh, it's just NNN, it's not,
Well, where did it?
no, it became 209.
Yeah,
So that
our thinking is it needs to be sent back to letters for ID.
Yeah.
So it'll be marked MM for ID.
That's great.
Perfect. And then the redacted version will now just become
209.
209.
Yes.
Yep.
All right, waiting for this Alessi argument, probably the spiciest one of the morning coming up. Then we'll go over some of the highlights.
And we'll hear
of
from
what's
you
happened.
this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Alessi, I'll hear you.
Here we go.
Thank you, Your Honor.
Get to the podium.
If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of. That's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally could state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
But Your Honor, the Commonwealth's position is ultimately I defer to the court as far as whether or not it's an appropriate instruction to give in the final charge. What the Commonwealth would submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the court's final charge.
Okay. All right, I'll hear you, Mr. Alessi.
May I go to the podium?
Yes.
Thank you.
You get the full argument then. If you're refusing to budge at all, you get the full argument from Alessi.
Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination and challenging Dr. Wolf on several aspects. And this one was particularly apt, the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis, and that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time, and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there, again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So, therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally.
Very briefly, Your Honor.
Keep your voice up, please.
Yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with a witness on the stand, things can happen. Mistakes can be recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury, and furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi. Okay?
Thank you, Your Honor.
All right. Anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45 ready to start. So things take a little while generally. That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during the deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that.
Okay.
But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, not at all.
All right, so we'll see counsel in here no later than 8:30 tomorrow morning?
Sure.
We'll have counsel here at 8:30. All right, thank you.
All rise to the court, please.
Stop. I get it.
Is there already one of these? Like, are we swapping?
Yes.
Goodbye.
Goodbye. All right. Couple things to talk about. First, about the judge looking for a way to exclude the instruction after she completely whiffed on the correction and waited till long after the event with the holes and the improper everything. Wow. You didn't object at the time. He's like, let me tell you why we didn't object. We didn't know what was going on. It was improperly produced. They have every reason. I think it was before the next witness had even started that they objected. I think it was timely. Couple things happened here. Let's go back to the charge conference. Absent witness instruction. This is the instruction the Commonwealth the defense initially filed, saying we want the jury to be told that there are some people you should have heard from and didn't. You could have concluded that we will hear from lead investigator, we'll hear from Brian Higgins, we'll hear from Brian Albert. You didn't. We want the jury to be able to infer that you didn't, because what you would have heard would be harmful to the prosecution's case. The Commonwealth dropped that request. It's been withdrawn. That's a strategic move. It seems to indicate that they think they're in a very powerful position right now with the jury. They asked for an instruction about the view, saying, can you please give the instruction about the rock that everyone saw on the view? Somebody put a rock right out there. Can you say again that wasn't there? Judge says, no, I'm not going to do that. The lost or destroyed evidence. The defense withdrew the request for the instruction about lost or destroyed evidence. They said, we don't need it. We don't need it coming in. The consciousness of guilt. The request has been withdrawn for an instruction about consciousness of guilt. I believe that I heard that it was withdrawn by the prosecution, but they still want to sort of argue it a little bit in closing, saying, but Karen Reed, after she did this, she took her car and hid it over her parents' house. She ran away. And also some of the statements she made to interviews. So we might see those in the closing. That's allowed. The judge may give the jurors a statement. This is probably one of the worst decisions of the day. The judge may give the jurors a statement that the Supreme Court requires her to read instructions in full that don't apply. Let me just stop for a second and do a little goat scream. If you read a whole bunch of instructions to the jury and then tell them some of these don't apply, unless you tell them which ones don't apply, they will pick and choose. And you might as well not read them any instructions. You're giving them the law they must follow and then saying, but not all of them. Some of them you just ignore those. No. Oh, it's terrible. If the judge does that, it's oh man, it's awful. There's a reason. There's not case law for somebody doing that. It's not allowed. Commonwealth is not requesting the lesser includeds. Those are requested by the defense. Sometimes the Commonwealth will go for lesser included because it's more likely to get a conviction when you have lesser included. I mean, there's murder, and then there's all the other charges all the way down to just simple assault that may be lesser included. And Commonwealth is not asking for those. Defense is. It's more. You're more likely to get a conviction with lesser includeds, but it's also more likely to be a compromise conviction. So that's going to come in. Defense asked for them and gets them, even though the Commonwealth didn't want them. Commonwealth wants to argue about consciousness of guilt about Karen Reed taking the car to the parents' house and the video clips, and that's going to be allowed. Then the big one with Mr. Alessi's argument, I'm a little bit frustrated, just teensy bit frustrated with the judge saying you didn't object in time when they literally laid out there are so many parts of this that are wrong. We didn't have the time to prepare to make an objection because it all happened before we were. You're never supposed to show something to the witness without showing the other side first or talking to them. I'm going to show them this. Never supposed to do that. And it all went sideways. So I think if the judge fails to give that instruction, she's basically autographing the appeal approval. It's terrible, a terrible move. The verdict form that confused the jurors last time, guess what the judge says? I like it a lot. We'll probably use the same one this time because it's so clear and jurors just understand their role better with my version, which last time caused confusion and a mistrial. Oh my goodness. The defense, obviously they gave a more wordy version, but the defense basically said, we took all the charges, included all the lesser includeds. And we say, start at the top, murder 2, guilty, not guilty. Not guilty, move on to the next one. And work your way down. And if they all say not guilty, then she's not guilty. Judge says, I don't know. It's just too confusing. We don't want the jurors to be confused by all the words. It says not guilty too many times on this page. And I'm concerned they're not going to reach the right conclusion because of the number of not guilties that appear. It's driving me nuts. It is terrible on that front. All right. Oh, Eric, you're getting your Pucky Puppy Boxster ST. If I could redo it, I would have got the ST. It's a little bulky to step over with the regular Boxer. They're the same bike, just one's easier to step over. Want to race? Mine's charged up, Eric. Bring it. Let's go. She did take all the words off the slides, and then she banned the slides. Yeah, the slide is not coming in. Not coming in. Nope. Does she not remember they were confused? They were confused about something that had nothing to do with her, apparently. Not the verdict. Her instructions are more robust than the proposed by the defense. She said that she likes her instructions. She is quite partial to her instructions. I don't know if it's laziness. I don't know what the reason is. Maybe it means she doesn't have to copy, paste, and delete something else. But she likes the way she had it. What was the poll result? About 5%, if I remember correctly, said guilty in one form or another. Everything else was a version of not guilty. This Joni Hockey says, all right, trying to send a super chat. Says payment went through, but haven't seen it in chat. Do you see anything? Let me look. Boom, boom. Greeners, today is officially a no sidebar day. Thank you very much. Kim R., I missed Thal and his tackle hugs. Got it. Amanda H., if Karen is found guilty, will she be able to stay on bond? Will her case is on appeal, or will she have to stay in jail? That judge gets to decide that. Jamie C., member for 25 months. Thank you, Jamie C. OG. Says, defense better check Jim's bag before closing arguments this time. Make sure all the names are included. Look for the hidden pocket in the bag. Seriously. I think the jurors have already been selected. We also got Kelly H., who gets a membership at the beginning of almost every live stream. Thank you, Kelly H., for your consistency and your support. Ellie Veldman, OG, member for 26 months. Good morning to you. Crafter Shells, member for 29 months. Good morning to you. Free Karen Reed, let's go. Ha hugs. Thank you, Shells. And Hannah, welcome to the gallery. That's the ones I have. I did not see it. If there was something else. Yes, show us the number ball. All right. The judge will jail her if she's convicted. Probably. It's usually the case. Depends on the sentence. If the sentence is like 10 years or less, they're usually allowed out on bail. But if it's 10 years or more, they usually are kept in. I like my second shout out. Can we have a palate cleanser? If I can find it. Let's see. Let me look. Looking for a good palate cleanser. Is this it? That's not it. How did I get all the way to Buchanan? Winnaboo, member for 16 months. Always here, seldom chat. Are we going to see your bike? Would love to see it. I might be able to show you my son riding my bike. Let's see. Let me just see how much this shows. Turn on Do Not Disturb so nobody texts me and suddenly gets their number shouted out all over the internet. All right, here we go. Let's go to camera 3. Here's my bike with a my youngest. That's it. It's fun. It's fast. He goes up to about 17, 18 miles an hour on that one. Quite safely. Dangerous? No. It's great. There it is, Joni Hockey. It came through. R.A. My cat, Miss Joni Hockey, jumped on the phone screen, and when I saw the screen, it said, I reported. I didn't mean to report anyone if I did. So whoever got banned from YouTube, it was Joni Hockey that did it. No, just kidding. It was the cat. Generally, a lot of people report. YouTube checks it. If there's nothing, it's fine. They know that accidents happen. All right. Deliberation tomorrow. Super excited. It was a butt report. The keyboard struggle is real. It's a constant battle. Took my phone and reported a comment a few days ago. A kid did. Nice. All right. With that, oh my goodness, we've got less than half a day today. Less than half a day. Where is the? I thought I had. Let's see. Where would it be? I thought I had a video to show. Mod chat. Do you have it? Josh, again for me? I'd recorded it, but I don't think I... Let's see. We have a Thurston County trial we could go to today. Josh, when does it start? Thurston County, it's about now, isn't it? They're just waking up. Let's see. Thurston County Court.
There's nothing in the order that restrains you from talking to cats.
What court number is it, Josh? Is it 1, 2, 3, or 4? 2. 2 is not live yet. 3. 3 is not live yet. And 4. We go to Vordaer. It's going to be Judge. It's going to be 4. Let's jump to this. If you guys have not been to one of the trials, and we're doing this because we don't have anything more today from the Karen Reed trial. If you've not seen a trial from Thurston County, you have not watched court. You're not a true crime addict until you've seen a court from this little room. Let's jump over here really quickly and take a look. This is an hour long. We get to see the jury on this one. So those are the jurors. They've never been that close together. Here's the judge. He's actually a commissioner who has agreed to, both parties agreed to treat him as if he is a judge.
Yeah. Okay. All right. Good afternoon, everybody. Welcome to Thurston County District Court. I am Commissioner Paul Wool. I'm the judicial officer who will be presiding over this trial. We've asked you all to come in here today to select some of you, 7 of you specifically, as a jury in this case. All right, before we get started with my remarks and questioning, I'm going to ask each of you to please stand and raise your right hand. And do each of you swear that you will truly answer the questions that are put to you by the court and by the lawyers concerning your qualifications to serve as jurors in this case? All right, thank you. Please go ahead and be seated. I have one more.
Well, he does this. The jurors, the lady in the red, orange, green, and black sleeve jacket, that's number 1. It goes 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17.
The questions I ask and the questions that I permit the lawyers to ask and the instructions I give are directed to all of the jurors in the courtroom. Each of you is cautioned to pay close attention to these proceedings. In order that this case be tried before an impartial jury, the lawyers and I will ask you questions. Not to embarrass you or to pry into your private affairs, but to determine if you are unbiased and without preconceived ideas that might affect the case. You should not withhold information in order to be seated on this particular jury. You should be truthful in your answers rather than answering in a way that you feel the lawyers or the court expect you to answer. It is presumed that when a jury has been selected and accepted by both sides, each of you will keep an open mind until the case is finally submitted, will accept the instructions of the court, and will base any decision on the law and the facts, uninfluenced by any other considerations. The purpose of the questions during jury selection is to determine if you have that frame of mind. The lawyers have the right and the duty to challenge jurors for cause, and they may also challenge up to 3 jurors without giving any reason. These are known as peremptory challenges. And you should not take offense if you are challenged, since the challenge is not exercised as a personal reflection on you. This is a criminal action instituted by the state of Washington as the plaintiff. The plaintiff is represented by Deputy Prosecuting Attorney Mr. Brody Weston, seated here. The defendant is Ms. Shannon Pardee. She's charged by complaint with 2 counts of the crime of violation of an anti-harassment order. And she is represented by her attorney, Ms. Michelle Rowe, seated here.
We've seen Ms. Rowe several
times. The defendant has entered a plea
good.
of not guilty.
She wins a lot.
That plea puts in issue every element of the crimes charged. The complaint in this case is only an accusation against the defendant, which informs her of the charge. You are not to consider the filing of the charge or its contents as proof of the matters charged. It is your duty to determine the case from the facts and the evidence produced in court. It is also your duty to accept the law from the court, regardless of what you personally believe the law is or ought to be. A defendant is presumed innocent This presumption continues throughout the entire trial unless you find it has been overcome by the evidence beyond a reasonable doubt. The plaintiff has the burden of proving each element of each crime beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If after such consideration you have an abiding belief in the truth of the charge, then you are satisfied beyond a reasonable doubt. And as this is a criminal case, the jury must be unanimous in order to return a verdict. Now, I'm going to ask you some general questions, and if you would answer yes or probably to these questions, just put your hand up and keep your hand up until the lawyers and I have had a chance to note your juror badge number. But don't express anything specific at this time. So first of all, have any of you ever heard of this case before? The state of Washington versus Shannon Party. All right, no one has, and I assume then no one has ever expressed to any of you an opinion regarding this case. Okay, no one has. All right, so do any of you know the defendant or either of the lawyers on either side of this case?
Everyone shook
and
their
I
head
did
or
not
said
introduce the other person sitting over here at the plaintiff's table, and this is Mr. Libby. He's a legal intern who works for the prosecuting attorney's office. He's a law student.
You can ignore me for the most part.
My boss
Do
does.
any of you know any of the following people who might be called as witnesses in this case? And Mr. Weston, would you state the names of the state's witnesses?
Thurston County Deputy Brennan Warnock and Jeffrey Ayden.
Does anyone know either of those people? All right, and I've already introduced Ms. Party, and there's no one else, correct? Okay. Very well. Have any of you ever had any personal experience with a similar or related type of case or incident? So I'll remind you the charges levied in this case are a violation of an anti-harassment order, a type of court order. Have any of you had any experience with that type of case or a related type of case as a victim, a witness to a crime, or as an accused? Okay, we've got juror number 2.
40 years ago, yes.
Okay. All right. Well, I'm just going to mark down your number here. And
juror 4.
Would this affect your consideration of this case? Okay. And then the next question is similar. Do any of you have any close friends or relatives who've had an experience with a similar or related type of case or incident as a victim, a witness, or accused?
Juror 2 once again.
All right. Again, that'd be juror number 2. And juror number 2, would that affect your consideration of this case? All right. Thank you. All right. Are any of you connected in any way with, oh, sorry.
Number 19 had her hand up.
Oh, number 19. You too? All right. And was that with regard to a friend or relative? Okay. Thank you. And would that affect your consideration of this case? Okay. Thank you. All right. Tell me if I missed anybody else. Okay. Are any of you connected in any way with the administration of justice? That would be courts, prosecutors' offices, public defenders' offices, or any similar agencies? Or are any of you connected with law enforcement agencies? Okay. And that's going to be juror number 1 and juror number 16. And anybody else? Just 1 and 16. Okay, for the 2 of you who raised your hands in response to that question, would this affect your consideration of this case? At what agency are you with?
I'm not connected.
Okay.
I'm on the board for the Auto Theft Prevention Authority.
Sure.
So I work with the police officers on the board, but I don't know them.
Okay, we'll take that as a...
Okay, she's off. She's on the board with some police officer agency. One in the back we can't hear.
Okay, a chaplain. Okay.
She's a chaplain.
Understood.
Nice. It's crazy. We get to see the jury on
And
this
then
one.
similarly, are any of you related to or close friends with anyone connected with the courts, the administration of justice, or law enforcement agencies? And that's probably juror 16. That's more similar to the question I just asked, but Same
Yeah, 20.
idea. All right, juror number 20.
Please keep your voice up.
Okay, thank you.
It's a nice jury pool.
And would that affect your consideration of this case? Okay, thank you. All right, and this question's an awkward one, but I will probably have to ask it two different ways. Would any of you be unable to assure the court that you will follow the instructions on the law regardless of what you think the law is or ought to be? So at various times throughout this case, I will be instructing you on what the law is. I've already done that at least once. I told you what reasonable doubt means. Can all of you accept my instructions on the law, even if you think the law is something different, or even if you think it ought to be something different? Everyone can do that? Okay, thank you. Do any of you know any reason why you might not be able to try this case impartially? Okay.
This happened
I
yesterday.
know we think
Case
that
starts
this
at 1
trial
today.
will last the rest of today and tomorrow.
What?
With those timelines in mind, does anyone have any reason whatsoever they should not be here to try this case?
No hands. Wait.
Okay, juror number 5. Animals, okay.
Animals to take care of.
Gotcha. All right. I think that was the only hand I saw go up. Okay, then I'm going to step back and turn over the floor to the attorneys to ask you some questions for the next few minutes or so. So first, I'll ask you to please give your attention to Mr. Weston on behalf of the state.
Mr. Weston, is this?
Thank you, Your Honor.
Is this Trenchcoat Weston? Nope, this is the new guy. There it is. Now refreshed, ready to go.
Okay. So who is actually excited to be here today? Raise your hand. Why? Okay, juror number 7. Why is that? That's a good reason. Anyone else here actually excited to be here? So. Juror number 9.
Say more, just to understand the process and what happens on the back end. So.
Okay, and I do apologize. I will be referring to you as numbers today. Please don't take it personal. If I could refer to you as names, I totally would. Is there anyone here that is actually dreading this entire process? Like, just doesn't want to be here, would rather be doing literally anything else? Wow, not everyone at once. Okay, jurors number 3. Why is that? Okay, about just being part of a juror or screwing something up? Okay, I mean, those are all good reasons. Juror number 5. Okay. Who else had their hand up? Juror number 4. Understandable. I know. I do appreciate you all for being here, even though you were kind of forced to be here. Juror number 11, I think you had your hand up.
Yeah, it's all of that, but also it was scheduled.
Okay. All right. And is this going to interfere with you preparing for your test at all?
No, sure.
Okay. Juror number 15, I saw you have your hand up.
Nobody wants to serve. This is typical.
Okay.
Most of the
Well,
excuses
sitting
don't
for
count.
an hour and a half at bother your back or bother you in any way, or okay. So yeah, like I said, I appreciate you all for being here. I know that you were forced to be here and you all have other obligations, but we wouldn't be able to do this without you. And so, reading the jury questions and everything, this is a pretty easy jury to, talk to. Nothing really, there's only a few questions here. So one of the things that the judge kind of mentioned was beyond a reasonable doubt, the concept of beyond a reasonable doubt. Does everyone here know what that might mean? Raise your hand if you know what that means. Okay, juror number 6. Mm-hmm.
Maybe I shouldn't lecture on this one.
Well, you know what?
I may not be the best person.
Well, luckily for all of you, the judge will provide you the law. And so there is a certain law that you're required to follow that will show you how, show you that I must prove each and every element beyond a reasonable doubt. So you don't have to come up with your own ideas or beliefs or anything. I just wanted to see how many people have ever actually heard of that idea or had fully understood what it meant. And so you've all been instructed by the court that the law presumes the defendant innocent until proven guilty. Is there anyone here that might not be able to, doesn't believe in that you're innocent until proven guilty? Okay. I might cold call on some of you. I had to suffer through 3 years of law school where they cold called on me. So hopefully that you don't suffer too much here. Now, the idea of reasonable doubt. So I'm going to kind of give you a hypothetical here. So imagine, this is actually a true story. Imagine that you're painting, who here has kids? Raise your hand if you have kids. All right, number of you have kids. So imagine you're painting a bedroom with one of your child. Your kid's a toddler, 3, 4, 5 years old. You're painting the walls. You run downstairs to answer the door because someone, you ran downstairs to answer the phone. Phone is ringing. So you're down there for a minute and a half. You come back upstairs and you see that there are handprints on the wall, painted handprints, like, from the paint all on the wall. What happened while you were downstairs for that minute and a half? Raise your hand if you have an idea. Juror number 2.
Depending on the size of the handprints, your child got into the paint and touched things.
Okay, so the child might have, put his hand in the paint and.
Depending on the size of the handprint.
So for the sake of the hypothetical, we'll just assume it's a child-sized print, okay? Is there anyone here? Yeah, all right. Is there anyone here that would disagree with that statement, that it wouldn't be the child? Juror number 4.
Well, if there's no paint on the kid's hand.
Okay.
Thank you, juror number 4.
So that say there is paint on the hand. Would you agree that if
Paint on the hand.
Okay. All right. So say found paint on the wall. Is it possible that while you were downstairs for that minute and a half answering the phone, your neighbor ran through the front door, up the stairs, into the room, grabbed the child's hand, put it in the paint, and put it on the wall?
Yes.
That's not possible? Raise your hand here if you think that's possible.
Who has a neighbor like that? Raise your hand. Yep.
Okay, so a majority of you think it is possible. Assuming aliens exist, is it possible that the aliens came down, put the child's hand in paint and put it on the wall, setting up the kid?
Yes, based on the assumption they exist.
Assuming, we all believe in aliens, and yeah, it's possible, right? But now let me ask you whether either of those explanations is reasonable here. When you have paint on the kid's hand on the wall, is it reasonable to assume that something other than what you guys initially thought was true?
Depends on the aliens that we all now believe in.
Now, you as a jury are going to be the sole. You guys are going to be in charge of determining the credibility of the witnesses. That is part of the job as a jury. And so, another hypothetical here: you have 2 kids fighting with each other. You are in the other room. You hear a glass bowl break. You come back in. Both kids say they didn't do it, but the glass bowl broke. What would you be looking for as, how would you know who's telling the truth?
Look for the cat.
Someone raise their hand here. Juror number 3.
She says, I'm just going to spank them both and send them to bed because it was one of them. They're both guilty of fighting.
Okay. Juror number 1?
Yeah, I think so.
And with that, you're off the jury.
What their version of the story is, try to look at how they're speaking about it, whether they're your kid, you probably let them tell.
Mm-hmm.
So you just love it. Hear their stories. I listen to them more.
Okay. Juror number 13, you had your hand up. Okay. So body language, whether their stories are consistent, things of that sort. Is there anything else that you anyone here might look for other than body language, or whether their story is consistent? I guess there isn't really much else to look at.
What I heard before it happened.
What you heard?
You said you heard them fighting.
Okay.
So if you hear them fighting, you may have heard the gasp of the one that knocked it over or something like that.
Okay.
You didn't see it. And like she said, you know your kids' tells and things like that. If they're your kids, you're probably going to be able to tell you which one is hot one.
This analogy
makes sense. 13, you had your hand up again. Okay. Juror number 7.
That's what I want.
Okay. Would you need all that evidence to? Okay. All right. That all actually makes a lot of sense there. Now, the crime itself is a violation of an anti-harassment order. Does anyone here not know what an anti-harassment order is, or a no-contact order? It's okay if you don't know. I might not have known until I started working here. Obviously, it's pretty much, it describes it based on the name, anti-harassment order, and a no-contact order. Is there anyone here that can provide any examples when it might be okay to violate one of those orders? Or I guess, is there a situation where it's okay to violate no contact order? Mm-hmm. Okay. Can anyone else think of any other ideas or situations where it might be okay? Knowingly. Well, I guess either way. I mean, do you think it matters if it's accidental or knowingly?
Yeah, he's off the jury. Prosecution doesn't want him. What about when the other person instigates?
Juror number 5.
No contact,
I use them. I'm using them in the same, like they prohibit the same they prohibit the same stuff. So you can't have contact with one person or another, and so they do the same thing, just different names. I'm just using them. Yeah, I'm just going back and forth here. Juror number 7.
They're both in the same house.
So,
this prosecutor's like, oh crap, I'm hosed on this case.
A scenario where someone is in the hospital, someone's visiting someone in the hospital, and you walk by that group.
Okay, so what I'm hearing everyone here say is, like, if there's it's circumstances where it's accidental, or like there's no choice other than like you both end up at the hospital, like obviously some things like that can happen. But does anyone here ever think that it's okay to knowingly violate an order? Juror number 2, I don't want to get too personal here, but you mentioned back when you were 17 that you might have been involved in something similar like this.
Tell us all what happened.
Okay. Can you kind of explain, like, were you the protected party? Were you the?
No, I was the one who was accused of harassing my girl.
Okay. And do you think your experience in that situation would alter or hinder your ability to remain impartial here?
It was 4 years.
And
Live and learn. No, I don't think it wouldn't change anything based off of the evidence. Either way.
okay.
Yeah, he is so gone. He is not on this jury. Oh, we have a hand. We have a volunteer. Number 4. Look up. Number 4 would like
That
to
is
speak.
all I have for. Oh, yeah, juror number 4.
The same thing as a restraint.
In a way, yeah, it kind of prevents one person from contacting another person.
Because I've got a lifetime restraint.
I've got a lifetime restraint order. What?
Okay. Do you think your experience in that would hinder your ability to remain impartial here? No? Okay.
So 2 and 4 are gone. They've got lifetime restraining
I guess
order.
before I sit down, is there anything else that I should know that anyone wants to share? If, feels that is important that I should know before I sit down? Okay, it's easy enough. Thank you.
All right, members of the panel, would you please give your attention to Ms. Rowe?
Mr. Rowe likes to remain seated.
Thank you, Your Honor. I feel much more comfortable sitting here with my notes, so I'm hoping I won't offend anyone by not standing up. I always like to start my line of questioning with you guys by asking this question. By show of hands, how many of you believe that my client here is innocent? Innocent.
Let's get them hands up. Put them up in the air. Put them high. Wave them around. 3's
I see some
3 looks
hands
around
raised, some not.
and then raised your hand.
Juror number 8, if I could ask you, why didn't you raise your hand? Pardon?
I think she's innocent until.
She's here, so she did
I
something.
see a lot of heads nod. Is the general consensus that until the state proves she's guilty, she's sitting here as an innocent woman? How many of you don't agree with that position?
Crickets.
Now,
5's just like covers her head.
by
I don't
show
want
of
to be here
hands,
anymore.
how many of you have ever experienced being accused of something you did not do?
Get your hands up, all you liars. Come on.
In all type of situations.
Everyone's hands up.
If I could, I know juror number
Juror number 5. You're an angel.
16, did you raise your hand? And so you were accused of something you didn't do? Was it while you were a child, or would you say it's while you were an adult?
Adult.
And how did that make you feel?
Bad, okay? Bad.
And what was the resolution of the issue?
We fought about it. I won. I have to make up words because we can't hear the jurors. Sorry. Juror number 5 refuses to raise hands for anything.
People
We got
might
divorced.
be accused of crimes they did not commit. Juror number 13.
You know what she's saying.
Bad blood led to someone being accused of something they did not do.
There was bad blood, so we had to spill it.
I think it's probably more in general. As adults, are you aware basically in life that there are times when people are accused of things that they did not commit? And in those scenarios, what type of evidence would you like to see in order to have made a determination as to someone's guilt or innocence? What type of evidence would you like to see? Juror number 2?
In today's world, video.
Juror number 19? I think that's, I'm looking, saying 19 and seeing 15. Juror number 15, you'd like to see witnesses? How many of you, by show of hands, Well, let me ask it in this way. Imagine you've been arrested, charged with a crime. You've been waiting for your day in court, and finally your day is here. How do you think you as the accused would feel? Your number 9. You.
Definitely anxious with the approaching.
And do you think there may be reasons why a person may or may not want to testify? What would those reasons, what would some reasons be that you think someone would not want to testify? Let me start with juror number 17.
I think the reasons could include
Juror number 11, I know you raised your hand.
Retaliation.
Now, if I were to advise my client that their testimony is not needed, would you hold that against the person if a person chose not to testify? I see you shaking your head no, juror number 3. By show of hands, how many of you would really, really like to see the person who's accused testify?
Okay, you guys are off.
I saw a hand go to your head, juror number 4.
4 is like, yeah.
Juror number, did I hear, see you?
Yeah, I just my hand.
Okay.
You talking to me?
Sure.
You say my number, so I was making
You're
sure.
right, you're right.
Constitutional right not to testify, right? Because you might incriminate yourself. That's just the reason why you may or may not want to. And somebody earlier, anxiety, words verbatim, some of the times they're twisted.
Juror number 12, did you have something to add?
I agree. I would like to hear from testify, but people say the wrong thing and you miss the meeting that's all against you.
Do most of you agree with these positions? Juror number 8, do you have anything to add? All righty. So building on juror number 2's position that it's a constitutional right, how many of you are aware that you have a constitutional right to decide to testify or not to testify? Are most of you aware of that position, premise? Juror number 10?
A couple you paid attention in 4th grade.
No, it's okay. I appreciate you. And so, is it the general consensus that my client here has nothing to prove? It's the state's burden to prove their case against her. So would most of you agree with that position? And do most of you agree that that should be the law? That that is maybe the scenario that is most accommodating to the person who's being accused? Would you want that constitutional right be protected? I know that juror number 3, you indicated early in our questioning that you just don't want to get it wrong. How many of you feel the same way? You just don't want to get the wrong decision. So what I'm hearing is that as a group, you generally like to see videos if there are available, witnesses testify if they're available. How many of you are of the position that when an officer is called to a scene, and has to determine what's going on basically in the heat of the moment, how many of you believe that
They always get it right.
law enforcement always gets it right? See, no one's raising their hand. How many of you have experience with situations or maybe know of friends or relatives who have been in the situations where law enforcement has actually got it wrong?
There are some hands.
Juror number 4, would you mind building on that?
I was a cop in the Navy for a while.
You tell us this now?
Sailor, his wife's got some wood upstairs, you know. I had to force him to leave, the sailor, and I couldn't kick them out, and that's because that's what the chief police told me. I had to escort the sailor out there, and they said, well, they, you know, so that was wrong with me.
I know
He was the bad
people
cop.
raised their hands. Does anyone want to also give an example? Juror number 17.
Because I worked in schools, I have a lot of
She works at schools and sees law enforcement
officers in schools. And
in schools.
my experience,
And they screw it up all the time, apparently.
to be an advocate and that's what we've been.
Juror number 4 needs an interview for sure. Maybe his own podcast.
Have any of you, well, I guess I'll kind of hone this on juror number 2. I know you indicated that you had an anti-harassment order against your girlfriend years ago. Did you agree that that anti-harassment order should have been granted against you?
No, not initially, but after it was granted, I broke it.
And what was the
I'm
result
a
of that?
career criminal.
Couple of days in jail.
And does anyone else have any experience
No
with
words on paper can hold
friends or
me.
family members that maybe were accused, were arrested, but the law enforcement really just got it wrong, got the wrong party? Anyone else has any experience with those type of situations?
19 back there. We're never gonna get to 19.
Juror number 19. I'm sorry, I can't see your number back
It's because
there.
you're seated, Misery.
You was being attacked by his girlfriend who was drunk.
Girlfriend drunk.
He's video with the phone, not video. He was talking about his hearing though.
Something about video. Drunk girlfriend and video. This is a bad mix.
When the police got there, they went straight to him, because he's a big guy, she's a little bitty woman. It just automatically did that on him. And started to arrest him. And everybody, no, it's her, you know, and she said, no, he attacked me. Yeah, it was.
Police got it wrong.
Was he
arrested the big guy.
arrested?
Oh, no, they stopped when they saw the blood on him. Until all the knives was actually full of dirt.
Blood? Knife
So they
wounds?
were
They went straight to him. And
They just started arresting the victim.
Understood.
Harry, my boy, thank you very much for the super chat. Appreciate it. Thanks for the excellent job on this.
So,
She should be almost done. Number 4, is there anything else you need to tell us? Like, do you have a current
ending the
warrant?
questions that I have
Or do you have a pending case in
for
court?
you at this time, so thank you so very much.
All right, members of the panel, the attorneys are going to come up here and we'll be having a bench conference. You won't be able to hear us, but you can take a break in place. But
stand
please just sort of continue to face this way because the attorneys and I will need to look at your badge numbers while we do this. Right. Yeah, and you can, she can join us up here if you'd like her to.
Everyone ignores the law attorney. He is not invited up to the bench conference. 18 back there has brought headphones. She's going to, well, she's caught up in the cord. If somebody could help her. 20? Or 20? Can you help 19? Okay, never mind. We got it. This is why wireless headphones are a must. 17 is the only one standing. She can hear better from that position. Current prediction, juror number 2, juror number 4, you're off. Juror number 5, I just don't trust you. You didn't raise your hand to any of the questions. Like even the ones that were easy, you didn't. I think we will probably seat a jury without going to the third row on this one. We only need 7 people. Remember, it goes across the front, then snakes backwards on row 2. So it starts 1, 2, 3, 4, 5, 6 across the front, and then straight backwards to 7, and then back to the left for row 2. Yeah, the guy who was like, "Oh, I was a cop for a while in the Navy." Didn't mention that when you said, "Does any family connected to law enforcement?" Oops, forgot that. And I also forgot to mention that I have a lifetime restraining order against me for a case. Oops, didn't bring that up when you guys asked if I had any connection or family connection either. So if 2 and 4 are out, there's a possibility we could have an all-female jury. It looks like we'd have an alternate, possibly male, with number 10 and 11. Don't think we're going to get past number 13. You could charge me money, and I'd tell you which ones to pick. I think 3. She doesn't want to make a mistake. A 3 would be a great pick if you didn't. If you thought the majority would rule, because she's going to go along with the majority. She looks around to see what everyone else votes before she votes.
And cause challenges. All right. So we'll start with cause challenges and start with state.
Oh, we can hear this. State has a 4-cause challenge. Who is it? Oh, they muted again. Dang it. We can only hear the judge. Number 4 just did the universal "we're dead" sign. Pull out his phone, updates his profile. Parole officer will never catch me here. Ha ha ha. Hashtag police station. Juror number 5 is not aware that the best way to get off a jury is by speaking a lot. She's thinking she can go unnoticed and not be selected, but it's actually numerical. A law student is wishing he had installed Minecraft or Minesweeper on his laptop for moments just like this. What's the weather up in Washington right now? I see a couple jackets. We've obviously got a little sweater vest type situation in seat 1. We've got a jacket in seat 2. Seat 3 doing the long sleeves. 5, 6 long sleeve. 7, that's just more like a fashion statement, doesn't look like a coat. 8 long sleeve, 9 long sleeve, 10 long sleeve, 11 wearing a jacket, 12 little hoodie over zip up, pull over. Is it chilly up there? Yes. Oh, we want to buffer a little bit since the trial's live. Okay, hang on. Wait for it. Okay, hang on. Let's skip forward. There we go. They're done.
All right, members of the panel, I will announce who the members of our jury will be. If I don't call your juror number, you're excused. If I
2 and
do,
4
then
gotta be gone.
You will be a member of this jury. So the members of the jury will be number 6, number 7, number 9, number 10, number 11, number 12, and number 13.
The whole second row.
So for those of you whose numbers I did not call, you're excused from service on this jury, and just
6.
check in with jury administration and they'll give you instructions if you're needed any more. Other than that, thank you very much for participating.
Get your card
The
stamped for
folks
free
whose
parking.
numbers I did call, can I have you get up from where you're at here and take seats over here in the jury box? And Ms. Garza will get you in the right order. 8 was stricken.
8, you're
She's
gone.
good to go. Okay.
Out of here.
Watch the wire here, buddy. Hold it.
Because they're wired, not wireless. Okay.
Oh,
So
me, my I don't want you to trip over the wire.
while they rearrange the furniture in the office there, we're going to do a quick update. Oop, that's the wrong one. Let's do this one. Let's see. Let's go District 4. Channel. We'll go to channel. It looks like they are starting. So we're going to go back to the beginning. We're just a couple minutes behind. Let's see where they start. Okay. We're going to skip the instructions and go straight to open. Is that okay? There we go.
Mr. Weston, your first witness.
Your Honor, the state calls Thurston County Deputy Brennan Warnock to the stand.
Hang on, were there no opening statements? Let's go to open. Let's see if there were opening statements.
No.
Here we go. Opening statements. This is going to be a quick trial. I don't think it's going to take 2 days. Openings were yesterday. Okay, then we're jumping straight to when he takes the first witness on the stand. Jury comes in. They stand up.
Seated.
There we go.
To the jury, welcome back.
We skipped openings.
Pick up where we left off yesterday. That's with the state. Mr. Weston, your first witness.
Your Honor, the state calls Thurston County Deputy Brennan Warnock to the stand.
Deputy Witness. Swear that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Go ahead and be seated. And Mr. Weston, you can start whenever you're ready.
Thank you, Your Honor. Deputy Warnock, what is your full name for the record?
My full name is Brennan A. Warnock.
And can you spell your last name?
Yeah, it's Warnock.
And what is your occupation?
I am a deputy sheriff with Thurston County Sheriff's Office Patrol Division.
And how long have you worked there?
I've worked there for approximately a little over 4 years now.
And do you have any prior law enforcement experience?
No, I do not.
As part of becoming a deputy, what is the training that's required to do?
So upon hire, Thurston County Sheriff's Office sent me to Washington State's 720-hour CJTC Basic Law Enforcement Academy. And upon graduation, became a certified peace officer in Washington State. That was August of 2021 after hire. And then after that, I participated and passed Thurston County Sheriff's Office field training program, wherein I was trained by a more senior training officer and then by a supervisor before being checked off to patrol the road.
So he was hired first and then trained.
Continuing training or anything of that sort that you have to continuously do?
There's not only state requirements for yearly training in various different facets of the job, but I personally sought out and gone to other training and I instruct multiple things at Thurston County. I instruct emergency vehicle operations, first aid, less lethal, and then I'm also an operator on our special weapons and tactics team.
SWAT team.
Now, throughout your years of being a deputy, how many investigations have you done involving a violation of an anti-harassment order, no contact order, something similar, anything such as that?
I don't know an exact number, but yeah, a lot. I'd probably estimate a few hundred maybe.
And is that with you being the lead investigator on it or assisting as well?
Lead investigator.
How many have you, I guess, assisted on and been the investigator on?
I would estimate hundreds.
Hundreds?
Yeah.
Now, I kind of want to bring your attention to September 3rd of 2024. Do you remember what you were doing that day?
I was on patrol that day.
Okay. And what was your assigned shift?
If I remember right, I don't remember the exact district of the day, but I was assigned to patrol a specific district, I believe in the northwest area of Thurston County.
And can you kind of describe to the jury what exactly the northwest region of Thurston County incorporates?
Yeah, sure. So the northwest region incorporates basically anything west of Tilley Road and anything north of Maytown Road in Thurston County. So Olympia, Tumwater, and the unincorporated county portions surrounding those cities.
And how long were you patrolling that specific region of Thurston County?
Like how long was my shift, or how long had I been doing it?
How long have you been patrolling that specific area? Like not the exact shift, but the length of time.
They switch around a decent amount on which area you patrol, but I've been on and off patrolling that area for the last few years.
And would you say you're familiar with that area?
I also grew up there. I'm very familiar with it.
Okay. Wait, what area did you grow up in?
The Tumwater, like the northwest region of Thurston County.
Okay.
This is home for him.
Now, on September 3rd, you mentioned that you were on patrol in that northwest area of Thurston County. Why do you remember that exact date?
I remember that date. It was the original call in my district regarding what started this incident, why we're here today.
Okay, and can you briefly describe what brought you out to that area?
Yeah, Jeffrey Ayden called in complaining that there had been a violation of an anti-harassment order that he had in place.
Okay, and after that, what did you do?
I proceeded to take the call, contact Mr. Ayden, and then investigate accordingly.
And did your investigation end on September 3rd?
It did not, no.
Okay. So on September 3rd, your investigation didn't end there. What happened after September 3rd? Did anything arise or?
Yeah, so I believe on September 11th, I was contacted by Thurston County Records after having, I guess, thought my investigation was closed or completed. I was contacted by Thurston County Records and made aware of an order that was active and served.
And were you able to find this order on the initial date?
I was not.
On September 3rd?
No, I was not.
Now, after you discovered that there was an order in place, what did you do?
After discovering there was an order, I began by looking up that order in Thurston County databases and through DOL databases, reviewed the order to look at the general restraints and overall stipulations in the court order. And then I reached out to Mr. Ayden to discuss the incident further and investigate further.
Okay. And did Mr. Ayden, I guess through your conversation with Mr. Ayden, did you do anything as a result of that conversation in the investigation?
Yes, I did. But after reviewing the order and speaking with Mr. Ayden, I became aware that there were potentially digital or online violations of a specific general restraint in the court order.
Ooh, Facebook's coming.
Okay.
It's got to be Facebook.
And I went and looked at those.
And so if I was able to show you a copy of that order, the anti-harassment order, would you recognize it?
I would.
Your Honor, I'm showing counsel what's been marked as State's Exhibit 2.
Would it be
May I
wrong to
approach the witness, Your Honor? Certainly.
would it be
And
wrong to
the
send
deputy
something
was
to
marked
Aperture
as
after this
State's
case is over?
Exhibit 2.
Thank you.
Do you recognize that?
As just a thank you for your service?
Yes, I do.
And why is that? Why do you recognize it?
It is that specific anti-harassment order that's the focus of my case and investigation.
And so prior to today, you've reviewed and seen this order, correct?
That's correct.
When was the first time you did see that order?
I believe the first time I saw that order was on September 11th of 2024.
Now, as a deputy of Thurston County, is it part of your job duties to be familiar with these type of orders?
It is.
Now, just estimating, how many times have you read an order or gone through an order with someone?
In the hundreds at least.
And so it's fair to say that you do it quite often.
Yes, that's correct.
Now, are you familiar with what the information in that order means?
Most of it, yes. Yeah.
Most of it?
All of it, yeah. Yeah, I'm familiar with them.
Okay. And so looking at the order, can you let the jury know what court issued that order?
Yes, the District Court of Washington, County of Thurston.
And who is the petitioner, or I guess the petitioner in that order?
The petitioner is Mr. Ayden. I can give.
No, that's okay.
Okay, cool.
And what does it mean when someone's a petitioner on one of those orders?
When someone's a petitioner, considering that the order has been already granted and it's valid and served, it means that there's certain restraints put on an individual that's identified as the respondent in the order. And those restraints are laid out in that said order.
Give me 1 second. Your Honor, the microphones are.
They're on.
These.
They're turning off the microphones. They killed the live stream for this? They killed the live stream. Why did he kill our live stream? Were they about to talk about something?
I give it to you on.
No.
It was 15 minutes ago. It goes up here and says turn off the mics, probably because they're talking about the restraining order.
Mm-hmm.
Good. They just killed our live stream out of Thurston County. It says they're live, but they're not. Look. We were a couple moments behind. I'm hoping it comes back on. We've had the voir dire. Then we got 12 minutes today. We'll hang out for a minute and see what happens. But can I tell you what happened? Yes, this is a restraining order case.
No.
You don't want to know about that one?
No.
Okay. Mrs. R.A.'s here. Well, we're waiting for them to come back. And Josh, if you can keep an eye on that for me, let me know if it does come back. Let me keep Mrs. R.A. up to date because she doesn't watch the show anymore.
I'm also kind of curious. How you feeling?
I've got a cold.
I don't know if I want to talk into this microphone.
You want this one instead?
It hasn't been breathed on.
My wife doesn't want my germs. All right.
Boy germs.
Okay. What happened? I can't see where we are today. We're right there. Okay. Yeah, we can see you. All right. Today we had the charge conference in the Karen Reed trial. And I was supposed to mention
what's the charge conference? What is that?
This is where the lawyers get together and agree on what is going to be sent to the jury as far as instructions.
Oh, yeah.
They finalize some of the evidence. Usually it's done before this, but they did that today. And they also...
finalize some of the evidence. You mean this is what we're going to allow the jurors to have back in the room if they ask for it?
just make sure that everything was admitted when it was supposed to be.
Oh, okay.
And they had
Paperwork.
a couple things there was an redaction that had to be done, and that was finalized. Now it's in. Things like that.
Okay.
The defense asked for and wants to use a Bowden defense, which is a defense where they say there was inadequate investigation.
Oh.
This is blaming the police.
I think this is justifiable in this case.
And it's allowed. It's in. They're not allowed to get into third party. So they can't say Brian Higgins, Brian Albert.
Okay.
That's out. And
well, honestly, I feel like
can't
that's a stronger defense anyway. Like you've got a lot more evidence to show that they muffed it than you do that there's a third party.
They can't even, sorry, I muted the wrong mic so I could sniff.
You muted me so that they could hear you sniff?
Yep, I'm good at that. It's because I thought you'd switch. They did want to use the defense saying the police should have sort of like Bowden third party cross the line, but the defense wants to say that the investigators should have investigated Brian Higgins. And that's not allowed. That's not coming in.
Okay.
So this is a little bit frustrating because pre-trial, the judge said, we're not going to allow you to bring in any evidence of a third party culprit unless it comes in as evidence. And they said, and during the trial, they asked questions, and they're like, it only came in because of their questions. And now she's like, well, there wasn't any evidence to support a third party culprit, so you can't talk about it.
Wait a second. Why was there no evidence?
Because the judge didn't allow it.
Wow.
So yeah, that's, you could read the handwriting on the wall for a while. But anyway, so that is what it is. Closings are going to be tomorrow. They're going to be about an hour and 15 minutes each. The couple things, the defense withdrew their motion for the missing witness. Strategic move.
Why?
They must think they're in a good spot.
But even if you're in a good spot, you can always better it. Why would they do that?
I don't know. I don't know what could have possibly gone wrong other than the judge just denying it.
Which, I mean, she could have, but then it's done. I mean, the answer is always no unless you ask. And here it's usually no even if you ask. But honestly, you got to ask.
They withdrew that one. They asked for a motion about the rock that was at the jury view that was on the scene of the property that wasn't there at the time. There was like a big rock sitting there that was like convenient. Hey, you could bang your head on that. They
joking?
They said, can you tell the jury, remind them that was not there? She said no.
Well, then I will just work that into my closing statements. Wow.
Yeah. They have asked for a much stronger instruction on Mr. Brennan's mess up, where he held up the sweater and said, these holes right there, did he consider those?
Yeah.
And the judge is considering that, but she responded and said, you didn't object to the time. And
then
Mr.
did they
Leslie
not?
sort of went off on her. They didn't object because they didn't know what was going on. They hadn't been shown that. Normally you're shown something and you're like, okay, let me consider that. Is there going to be objection? Yes, no.
Yeah.
And then it proceeds. No, he just showed it to him and just went. And after the fact, they're like, we didn't even know what was going on.
Yeah.
And so I think that she'll give them something, but not everything they want there. The consciousness of guilt instruction is withdrawn. But
remind me, what is that?
That's where they're talking about how you can say her behavior shows that she knew she was guilty because she got in her car and drove to her parents' house and hid the car over there.
Oh, yeah.
The instruction's gone, but defense still gets to argue it.
Defense is arguing
Or sorry, not
that?
defense, but Commonwealth gets to argue it. Both with that and with her television comments. And see, the judge may give, this is terrible, think this one through. The judge may give the jurors an instruction saying the Supreme Court requires me to read all these instructions in totality, and some of them don't apply. Stop for a second.
Yeah, I'm stopped. I don't get it.
If the jury hears a bunch of instructions and then is told...
But some of them don't apply?
Yes.
You can choose which ones don't apply?
Yes. Yes.
She's not going to tell them which ones don't apply.
She better say this one doesn't apply, but I'm required to read it. That's the right way to do it.
But that's not how we roll in this court.
No, she's just going to be like, some of the jurors, some of the instructions you're going to hear are required to be read, but don't apply in this case. And then she's going to read a whole bunch of instructions, and the jurors are going to be like, so which one of those applied?
Yeah, really. So that it just becomes whichever side you're already on, you're going to choose the instructions that that better facilitate that. That may come back and bite her.
I think hopefully she's thinking that over. I hope she thinks it and comes to the right conclusion and does not give that instruction. I think it's terrible, terrible. Commonwealth is not requesting lesser included. Defense is.
Wait a minute. Commonwealth is not what?
Not requesting lesser included.
But
the defense is, and with one does, they come in. So defense is basically saying we want all the way down to driving under the influence as an option.
Because they feel like if you...
Which means she's probably going to be convicted of something.
Of something, yeah.
Of something.
But they think that it will be the lesser something if they give them the options.
Yeah, it would be a compromise. But...
Ooh, I don't know how I feel about that. I can see where they're coming from, and I see, especially having gone through this before and having listened to the jurors and heard their thinking about how they got to the conclusion they were at last time, I can see how they would say, we better leave something on the table so that, because they were solidly, she's guilty of driving drunk, because she was, but probably.
Here's what I'll say. They have a test from Karen Reed long after the fact where they say, based on what this test is, we're going to do math backwards and determine how drunk you were.
Yeah, which is, I mean, that doesn't work with how the body metabolizes.
Well, they have some numbers, and it's a range and everything else, and that math adds up. The problem is you're asking someone who drinks if they had how much to drink, and everyone's like, "Oh, I had 2 beers." Right. That's how much have you had to drink tonight? 2 beers. Doesn't matter how much it is. They ask her how much she had to drink, and she's like, "Oh, I just had some last night. That's it."
Yeah.
If she drank any more since then, that number's way off. That math is way off. She might have been completely fine to drive last night, had more during the night. We know she was up.
But I'm not buying that one. We saw how many drinks she had before she drove, and that was a lot of drinks.
Cinnamon Bear says DUI lesser is not included. I heard Mr. Yannetti include that one. OUI, operating well under intoxication.
They need to stop changing the acronyms. I can't handle it. My
Every
brain's
state
too
does it
old.
different. He used OUI up there. So I think that one is in some form. But,
okay.
Sorry, I have to look at the screen as well behind you. So,
anything else happen in court?
No, that's pretty much it. Mr. Alessi argued strongly for a statement against, correcting the issue with Mr. Brennan. And the judge seems implied to not do anything further than what she did, other than say it happened on this date with the holes. And the correction she gave was one sentence. It was even less than she said she would. Didn't include the date, and was done well after the incident happened.
So here's my question: do you think whoever does the closing on the defense side goes scorched earth and is like, we are just going to mention everything that should have been mentioned, that wasn't mentioned, and we're going to get objected to, and we don't care. We're just going to blow through this and get the information in front of the jury? Or do you think that they will stay in bounds and use their time to hit all the things that they feel are most important, or maybe some sort of amalgamation?
Here's what we have. Defense has a very strong defense in this case. They have both their experts and the Commonwealth experts who say that these injuries could have happened without a car accident.
Just falling.
That this is something that happened just from falling.
Yeah.
There's no evidence on the arm that this happened. The medical examiner says no collision. They have all this evidence supporting them.
Yeah.
So they have a strong case. I don't think they need to go in there and you'll be like, but you should have pulled Proctor in because that might distract them from the fact that they have a very, very strong case. I still think at some point in the closing, Al Jackson, if he's giving the closing, is going to get up and say, Mr. Brennan manufactured evidence in court. He held up this shirt and said, what about these holes? And they were made by his own criminalist a year later.
Yeah.
I think they're going to see some attempt to bring that in, especially if the judge does not give another statement. But I don't know if that's allowed. It will probably be objected to and sustained halfway through.
I'm going to have a hot take here, and I'm going to die on this hill. Alan Jackson lost the case last time in his closing arguments. And I I think he could have won it. He was so close. Well, that and then the badly wording of the actual documents, the verdict forms. But when he went out there and went full tilt into it wasn't her, it was them, you left them having to say, but I don't have enough evidence to support that it was them. And I just don't think it was explained clearly enough that it doesn't have to be them. It just doesn't have to be her. And so they were left saying, was it her or was it them? And that's what they had to decide from because of the way that he closed. He made it seem so them or her, that's it. And I feel like, Jackson, it's just reasonable doubt. What are you doing? So I really hope he cleans that up this time.
I think what hurt him was the time limit. The 1 hour limit that the judge gave last time, it was not enough. And you couldn't go over all the evidence and build the closing and walk the jury through it at that time. We've got an hour 15. That's better.
Yeah. Well, and I mean, quite often in the closing, they will walk the jury through and say, this is how you fill out the paperwork. Check this, check this, check this. And they didn't have time to do that. And that was a major part of the kerfuffle that happened is they did not know how to fill that out.
Yeah. The verdict form was definitely an issue. Luckily, the judge is aware of that, there's been a lot of criticism of the verdict form. She's considered that and thinks that it's a great form and she'll probably use it again.
You're joking. You are joking.
No, I'm not, unfortunately. I wish I was.
This is such a tragedy. What is happening? It's like a dumpster fire train wreck all at once. Oh my goodness.
This is a dumpster wreck.
Goodness gracious. Just fix the things that are obvious to fix.
Okay.
I think that it's got to be hard for the judge because if she's aware of anything ever, she's going to be aware that a whole lot of people don't like her because of her behavior in this court case. And it's just human nature. We dig in and we say, oh yeah? Guess who's in charge right here? And I think there might be a whole lot of, oh yeah, coming from her.
Yep.
So,
a couple other things. I was going to make a purchase once the trial's over.
Yeah.
On Amazon.
Oh yeah?
Yeah. I'd just like to send, just by way of thank you, maybe a nice card to Dr. Welcher along with some fruit snacks.
Yeah?
Welcher's fruit snacks. Just say thanks for your help in this trial. Appreciate all your efforts. And send him some finger paints. And is that a bad thing?
Yes, it's bad.
If it's a nice thank you, I mean, I'm not going to draw like somebody giving the bird or something on the card. I just think, a lot of experts don't get thanked for what they do.
Yeah, that's true. That's so thoughtful.
He saved me having to break my arm on my taillight.
And I am grateful for that, really, because the whole lack of insurance thing, that's nice to not have to deal with. Oh, my goodness.
Court is back in Thurston County. They're back. They brought it back live, so we're ready to go there. Mrs. R.A., I'm sorry you need to move so I can watch it. We have to listen. We're in the middle of an argument by the prosecution about a gripping case where somebody is accused of breaking a restraining order.
Oh, okay. But you're going to help the boys in the bathroom, yeah?
Sure.
Okay.
After this last trial.
Okay.
All right.
We'll see you guys.
All right. Oops. Oh,
Hey.
Look out. Sorry.
Actually have restraints put on them, specifically in regards to the protected party.
And kind of going into the restraints or restrictions, are there? How does the respondent know what they can and can't do based on that order?
It's laid out in the order in a section usually referred to as general restraints or other.
And are there any restraints in that order that that you found that might be important in this case?
There are. Am I allowed to flip into it?
Yes, you are.
Okay. I'll find it really quick. You want me to list it?
I said after the trial.
If you could.
After it's over. I wouldn't do anything during a trial.
Do you want all of the general restraints?
No, just the restraint that you were focused on in this investigation.
So the restraint that I was focused on in this investigation was subsection C of the general restraints portion. It's titled stalking behavior. Do you want me to read the restraint?
If you could read the provision word for word.
Yeah. So word for word, stalking behavior. Do not harass, follow, monitor, keep under physical or electronic surveillance, cyber harass, as defined in RCW 9A.90.120, or use phone, video, audio, or other electronic means to record, photograph, or track locations or communication including digital, wire, or electronic communication of the protected party, the protected person.
And in this case, who was the protected person?
The protected person in this case was Mr. Ayden.
And so if you're a respondent, such as the defendant in this case, how would you know that you're required to follow that provision?
It's laid out in the order that is served to you and a box specifically checked.
And is that box checked on that order?
That box is checked.
Now, if looking at the last page of that order, can you let the jury know when that order was signed by a judge?
I love the thumb twiddling.
So on this last page, it's ordered for 1, I believe it's 10, it might be 16 of 2024 at 10:13 a.m. and it has a judge's signature affixed to it.
And I believe on the first page, can you let the jury know when that order is set to expire?
The order is set to expire on 1/16 of 2025. So likely it was signed on the 16th, not the 10th.
And so
2024.
So during your investigation, was this order in fact valid?
Was it
was valid within that period before expiration.
Your Honor, the state would like to publish the order for the jury.
Is there any objection to the admission of exhibit number 2?
No objection.
Number 2 be admitted, and yes.
Now, after you looked over the no contact or the anti-harassment order, saw that provision, what did you do then?
I was directed to look online to the Facebook app on a specific profile for specific digital evidence that existed of violations.
Okay, so there's a whole lot
Yeah,
there.
I'm
So we're
sorry,
okay, we'll just kind of break that down. So you were directed to a Facebook page.
Correct.
Can you let the jury know what Facebook page that was?
Yes, I believe it's called Concern for Evergreen Shores Beach Club.
And where
That's
is
where I'm going.
that neighborhood or community located?
Evergreen Shores is a neighborhood that's located in the northwest portion of Thurston County in the district that I was patrolling.
And is that is based on your knowledge of the area, you being a deputy and also living in the area for your whole life, is that the community that the victim and defendant live in?
That's correct. Both the victim and defendant live in the community Evergreen Shores.
Now, so you went to that Concerned Evergreen Shores community Facebook page. What did you find?
I found 2 specific videos. I believe they were from September 8th and September 9th that depicted what I interpreted as door violations.
And just to clarify, that was what year were those videos?
2024. Sorry, 2024.
And so let's kind of start with the September 8th video. What you watched the video yourself, right?
I did.
What did that video show?
That video depicts what I knew to be Mr. Ayden's fence line and property. And it was from an angle or perspective from Miss Party's front porch or from her property.
And how did you know that that was Mr. Ayden's fence or property?
I'm very familiar with the area, and I've specifically been to that spot in between both properties, been to both properties numerous times.
And you mentioned the video was taken from a perspective from the defendant's property. How do you know that?
I have been to that same spot on the property and know what it looks like from there.
And so going back to the September 8th video, the one we're talking about, what was the video of exactly?
It was a video of Mr. Ayden's fence line and property of where his residence is from that angle.
There's a bunch of these videos up on that page.
Based on reviewing the video, who took the video?
Miss Party.
And what makes you think that?
It's from her residence posted on an account on Facebook that has her first and last name on it. In a concerned Evergreen Shores community page that is the community she lives in.
And is there any reason to believe that it was someone else that took the video instead of the defendant here?
No, there's not.
Now, the video you watched on September 8th, was it captured by a Ring camera, surveillance camera? I mean,
it appeared to have been captured by a cell phone.
And why do you think that?
I guess so. In contrast to what a Ring camera or a surveillance camera would have looked like, this did appear to be held at eye level, and the camera was noticeably shaking around a little bit. So it wasn't stationary or mounted to anything. Didn't appear to be.
And how long was that video on September 8th?
I believe it was just a few second video.
And how did you capture the video yourself in the investigation?
But unfortunately or fortunately, I don't have any social media, so I used a phone with social media and then recorded the videos on my actual county assigned work phone. So,
and did you record the entire video or just portions of it, or
just portions of it?
Now, if I was able to show you that video from September, actually, let's kind of backtrack there. You mentioned that there was a second video from September 9th, kind of doing what we just did with the September 8th video.
Mm-hmm.
What was depicted in the September 9th video?
The September 9th video was a near identical depiction of Mr. Eden's fence and property from a very similar perspective. It might have been a slightly different spot on Miss Party's property that was taken from, but it was still the same depiction.
And was it posted anywhere? Or
And that video was posted to the concerned Evergreen Shores Beach Club Facebook page under the same profile name, Shannon Pardilla.
And is there any reason to believe, based on your investigation, whether someone else took that video and posted it on Facebook?
There's no reason to believe that.
Then, if you recall, do you remember how long that video might have been?
I believe the September 9th video was another short few second video that I took in the same method as the September 8th one, or that I captured on.
Understood. Now, if I was to show you these two videos, would you be able to recognize them?
I would.
Your Honor, I'm showing that witness what's been marked as State's Exhibit 3. If you could identify what that might be.
That would be a flash drive with my initials and a date on it.
Okay. And what are your initials?
BW.
And what is the date on that tag that you signed or you initialed?
June 12th of 2025.
Pause for a second. Hang on.
And what was
the Facebook page was Concern for Evergreen Shores Beach Club members. Was the one that I was looking at, and it's just a complaint page. It's like it just goes off. It's crazy.
On that flash drive.
That flash drive contains those two specific clips from that page that I just mentioned that we just spoke about.
And when you reviewed the two clips on that specific on that flash drive, were they fair and accurate representations of the videos that you saw?
They were.
And after reviewing that flash drive, would you say that they're fair and accurate representations of the surrounding areas, including the properties and whatnot?
They are.
Your Honor, if the state would move to admit and publish State's Exhibit 3 at this time?
Yes, then number 3 will be admitted.
Your Honor, if I may show the jury
I might have to mute this because some of the videos show the party who requested the restraining order, his house, and it has music blaring. He also has flags, I think police thin blue line flags and stuff hanging from his fence. So I'm guessing there was a political idea, belief difference between the two parties as well. I'm just looking at videos up on that Facebook page they cited in court. It's open to the public. And the defendants, some of the posts from the defendant are still there as well, showing the fence line. We may not see these because the court.
If I could just move over there.
Absolutely, yeah. You can get them going where you need to see that. It's fine.
So, Deputy Warner, I just showed you the brief video that you took from September 8th of 2024. Could you kind of relate to the jury what exactly that was that we were watching, that you watched? If I have to replay it, I totally can.
No, it's fine. I can elaborate on it. That's like I stated before, it's a fair and accurate representation of what I found on the Concerned Evergreen Shores Beach Club members Facebook page, posted by a profile listed as Shannon Pardee, from the perspective of her property, looking towards Mr. Eden's fence line and property.
And now, if you look right under the defendant's name, it says 4 days ago.
Mm-hmm.
How do we know that that happened on September 8th?
It's 4 days prior to me recording this, which would have been on the 12th of September, making it September 8th of 2024 when it was posted to Facebook.
And based on you being in the area, you being familiar with the area, can you identify what city this is in?
Well, it's unincorporated county, but it's right outside of Olympia, Washington.
And what county is that?
Thurston County.
And what state?
Washington.
Patricia, OG.
Now, looking at this
21
video,
months. Time flies. Thank you very much.
does it say when the video was posted?
This one says 3 days ago. And again, as of September 12th of 2024, when I captured this video evidence, that would have put it at September 9th of 2024 when it was actually posted to Facebook.
And so based on your familiarity with the area, what are we looking at there?
We're looking at another depiction of Mr. Eden's fence and property from within the chain link fence on Miss Pardee's property.
And based on your familiarity with the area, where does it appear that this video is being taken from?
Do you want the address? Sorry.
No, just the location.
Okay, from Evergreen Shores near Olympia, Washington.
I guess
from Miss Pardee's residence.
And is it possible that this could be just a video of a Ring camera?
I don't believe so. If you don't mind playing it one more time, so I can assure that this one is also shaking. I don't believe it's from a Ring camera, though. Yeah, so I don't believe it would have been from a Ring camera. It appears to be from a cell phone.
And I'm not sure if I asked about this specific incident, but what county was this in?
Thurston County.
And the state?
State of Washington.
Just had a JetBlue plane in Boston, Massachusetts roll off the runway into the grass.
Nothing further, Your Honor.
No injuries reported. Oops. Okay, cross-examination from Ms. Rowe.
Good morning, Deputy Warnock. How are you today?
Not too bad, thank you. Good morning.
I want to bring your attention to the no contact order. Do you? Is this the certified copy of the anti-harassment order that you were referring to?
Yes, it appears so.
I'm going to leave this here and I might ask you a couple of questions. If I could bring your attention to page 4. And if I could ask you to look at the top of the page, is the box where it says stalking, or are you on page 4?
I am, yeah. Yep.
Is the box that checked that that is titled stalking protection order?
The box that says stalking protection order is not checked.
And I'm now bringing your attention to page 6 of 12.
I'm there.
Is the box noted as section C? Is that box checked?
The box noted as section C is checked.
And what's the title of that box?
The title of that box is stalking behavior.
And you are familiar with the items that are listed in this checked box, are you not?
I am.
Right, and it indicates that the restrained person is not allowed to harass the protected person. Is that correct?
Yes. Yeah, that's correct.
Follow the protected person. Is that correct?
That's correct.
Monitor the protected person. Is that correct?
That's correct.
Keep under physical or electronic surveillance the protected person. Is that correct?
That's correct.
Cyber harass the protected person.
That's correct.
Or use phone, video, audio, or other electronic means to record the protected person.
That's correct.
To photograph the protected person.
That is correct.
To track locations of the protected person.
That's correct.
The communication of the protected person.
That's correct.
Do any of these specified acts include taking a picture of the fence?
They don't specifically specify taking a picture of a fence.
Do they specify anything regarding taking a video of a fence?
Not of a fence, no.
So is it your understanding that the anti-harassment order restrains actions as they are related to the protected person? Is that correct? These ones that we've just read off.
I'm sorry, could you ask it one more time?
Is it safe to conclude that the anti-harassment order follows actions directed at the protection party?
It is.
You need a burner account, Stacy. The page is concern for Evergreen Shores Beach Club members. Left members off. You have to go to Facebook and search for that. And you'll see posts.
So, Deputy Warner, you're going to flip to page 10 for me, the harassment order.
I'm there.
And at the very bottom there, does it say whether the defendant was ever served with this no contact anti-harassment order?
It does say.
How do you know that?
If you don't mind, I can read the box down there.
Please do.
Okay. At the box, under service on the restrained person, at the very bottom, there's a box that says service is not required or not required. The restrained person appeared at hearing in person or remotely and received notice of the order. No further service is required.
And so as your experience as a deputy, is there a difference between a stalking protection order and an anti-harassment protected order?
There is, although I will caveat that by saying that stalking behavior is a very, I have seen the box checked numerous times in anti-harassment orders. Anti-harassment orders are much more frequent and commonly have a stalking clause, as we saw that I read earlier.
Now, defense counsel mentioned how the clause that we're really focused on here, the stalking behavior clause that you previously referenced, talks about the protected person. Based on your training and experience as an officer in enforcing these anti-harassment orders, reviewing, interpreting these anti-harassment orders, is there a difference between the protected party and the protected party's property?
There is, but there at the same time is a lot of simultaneous action between the two. I guess I can give an example as like an exclude or stay away from. It usually says the protected party's property or residence, but also includes the protected party. If that answers the question properly.
Yes, it does.
Okay.
Thank you very much.
I think those are law students back there. Interns.
Nothing further at this time, Your Honor.
Is there any recross, Ms. Rowe?
Yes, just one question. I believe you just testified that, as your example, there are anti-harassment orders that require somebody to exclude and stay away from, and those would encompass the person and the person's property. Is that correct?
That's correct.
And if I could bring your attention to section B on page 6, is that the section you are referencing?
Section D, exclude and stay away from, or stay away is the subsection I was referencing to, yes.
But in this protection order, that is not checked. Is that correct?
That's correct. There's no requirement for Ms. Pardee to be excluded or stay away from.
Thank you. No further questions.
She's getting a not guilty.
Thank you, Deputy. You may step down.
Thank you, Your Honor.
Prosecution rests.
Mr. Weston, the state's next witness.
Yeah, give me 1 second, Your Honor. Let me go get him real quick, all right?
Kelly, this sounds absolutely crazy. A community page. Yesterday's post was Lauren that works at Captain D's. Please find your own husband. Oh my goodness. Facebook is spicy. Karen Reed trial is on break right now, so we've got a filler trial. This is up in Thurston County, Washington. Little restraining order violation, allegedly. It's going to be a quick one-day trial. one day for us. Probably only one more witness for the prosecution, and then defense will most likely not have any witnesses. And then the jury can come back with a not guilty. As Ms. Rowe often gets a not guilty. She does. She's not the most polished speaker, but I guess she just takes cases that she knows she can win. The stay away order has no requirement to stay away. No, the order only ordered her not to have harassing behavior or stalking behavior with the individual, and it didn't say stay away from the property. She took a picture or a video of his fence, and that apparently was enough to get her charged. Kelly, you want the Father's Day gift? This is okay. I think this is a great Father's Day gift. Hang on. This is this is a little tiny. This would be for somebody who has everything, right? And I admit, full up front, this is just a toy. This is just a toy. I've been thinking about getting one myself. I've only seen them in videos, but it is it's a gift idea for you. That is an affiliate link. If you do happen to click on the link and then order something from Amazon, Amazon may reward me with a small thank you donation or reward. That wouldn't cost you any extra to make any purchase after clicking that link. It's a little tiny. If you ever seen those little, it's like a little, the ball that has the electricity inside. It's like that, only there's no glass around the outside, and it's safe to touch. And it makes sparks, and you can hook it up as a speaker to like your phone, and it will play music in sparks in the air. It's wild. It's wild. It's really cool. It's a fun little science toy, and kids love it.
Calls next Jeffrey Ayden to the stand.
This is the guy who owns the property.
Here, Mr. Ayden.
This might be spicy.
Mr. Ayden, raise your right hand, please. Do you swear the testimony that you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, please have a seat and turn your phone off.
Thank you, Mr. Ayden, for being here. First question is, if you can say your name for the record.
Jeffrey Wayne Ayden.
And can you spell your last name for me?
Eden.
And where do you live?
8015 Greenridge Street.
Sorry about that.
Olympia, Washington.
And what county is that?
Thurston County.
And what state?
Washington State.
And what do you do for a living?
Commercial truck driver.
And how long have you been doing that?
Since 2005.
Now, I understand you might be a little nervous. If you can slow down a little bit there, I would appreciate it, along with jurors as well.
Okay.
Now, I kind of want to hone in on what I showed you earlier today is State's Exhibit 3, which was a flash drive of, do you remember what was on that flash drive?
Yeah.
What was on there?
The videos of my property.
And how many videos were there?
2.
And when you saw that flash drive and watched those 2 videos, were they a fair and accurate representation of your property?
Yes.
Give me 1 second here. So I'll show you both videos real quick. So that's one of the videos.
Okay.
That the deputy took, and then here's the other video
Okay.
that the deputy took as well. Now, looking at both these videos,
they're like 3 seconds long.
What are we looking at here?
Oh, we're looking at my property and her mailbox.
And that, how do you know that's your property?
Oh, because that's the fence that we had to pay to put up, and those are our flags, and
how do you know that it's the defendant that took these videos?
How would I know?
Yeah.
Because that's the hood of her car right there. And she's the only one that would be taking those videos over there. And this has been going on for so long.
That's
yeah. Okay.
And so, based on your familiarity with it,
I'd ask the court to strike Mr. Ayden's last.
The jury will disregard that last response.
Now, looking at the perspective of where this video was taken, can you tell where it was taken from?
Well, I've lived there for 53 years, and that would be directly in her driveway, straight across from her mailbox.
And
there's a road right there. She's in her driveway, and that's looking across the street to her mailbox, to my property.
She's
and
on
when you say she, who is she?
her driveway.
Shannon Party.
And if you could identify her for the record and where she is in the courtroom today.
She's right there.
And you say right there, can you identify a piece of clothing?
Tan, pink looking flowered shirt, glasses.
And let the record reflect that the witness, Jeffrey Ayden, has identified Shannon Party as the defendant here. Now these videos are posted on the Evergreen Shores Beach Club members. Are you and the defendant members or in that community?
How do I know those are?
Well, how do you, I guess.
Just, there's so many people watching her. So I know.
Objection.
I would not answer. I mean,
yeah.
Sustained.
I guess, do you live in the Evergreen Shores community?
Yes, I do.
And the defendant lives in the Evergreen Shores community.
Right across the street from me.
And you might have mentioned this prior, but do you have any reason to believe someone other than the defendant took these photos?
Absolutely not.
And do you have that same belief with both photos?
Yeah, they're absolutely her taking them.
She's on her own property filming. That's got to be allowed.
Nothing further at this time for the witness, Your Honor.
Sir?
Your Honor, I don't have any questions for Mr. Ayden.
All right, Mr. Ayden, you may step down, sir.
Do they have another witness?
I can have 1 minute, Your Honor.
He might have another witness. She filmed his fence from her driveway, from inside her car. This is coming as stalking behavior, is what they're saying it is. I'm not seeing it. I'm not seeing it. That was the smoking gun right there. Was he on the video? No. It's the outside of his fence where he has a couple flags. There's so much tea to be spilt, though. I guess we'll have to take it to the Facebook page. See if there's another witness. I've got her not guilty when the cop said there's a difference between property and people on the restraining form.
Could I let them know that they might be, well, never mind.
Okay. All right, Mr. Weston, anything for any further witnesses from the state?
No, Your Honor, the state rests at this time.
State rests, okay.
And
Defense.
Ms. Rowe, do you need a recess before we go any further, or are you ready?
We're ready, Your Honor.
Okay. Then defense first witness.
Your Honor, we don't have any witnesses to call. Thank you.
The defense
rests
rests.
as well.
Yes, we do.
Okay, here we go. It's going to the jury.
Members of the jury, at this point, although that may have seemed short, you have heard all the evidence that will be presented to you during this case. The next step in this case is that we're going to give you some further legal instructions, some further instructions on the law. And after that, you'll hear closing arguments of counsel. So if you please go with Ms. Garza to the jury deliberation room, we'll bring you out shortly for your instructions.
All right. I don't know why she was filming, but she did film his fence from inside her car on her driveway. That's a public-facing fence, as seen from somebody else's property.
You go ahead and be seated. The state submitted a package of proposed instructions.
Yes, I also have some hard copies here as well, if you like those.
Sure, if you have them in hard copy, that's great.
I think the boss didn't like me.
Mr. Weston, do you have an extra copy?
I do, yes.
Ordered
Your
fudge
Honor, if I can
online.
just breeze through them real quick, I believe I like to have minutes.
Instructions on there. Jury proposed instructions. I'll give this copy here. Instructions, jury and my instructions, proposed instructions. Okay.
I guess the state's arguing that the posting of the video of his property on the Facebook page amounts to stalking behavior. That's as close as I can see. The problem was the stalking behavior was not in reference to property. It was just to persons. I think it's a technicality, but I think it's a significant one. The officer did say there is a difference between the two. This one is not checked. I've got to go with not guilty here. Oh, there's no question in my mind. These two have been feuding, and she is doing everything she can to spite him. But I think technically, the restraining order did not prevent her from doing this particular activity. They would make a cute couple. In another life, in another world, with a different set of circumstances, they might have met and been best of friends. Not in this one. Last time we were in Thurston, the jury returned a verdict. And after reading it, we found out that it was not, in fact, unanimous. Only in Thurston. Only in Thurston. She Googled Scent Bunny. I can't show your message, but it made me chuckle. Sorry. You have to be, let's not, yeah.
Your Honor, I am at this time.
Going to move for a judgment of acquittal. Do it.
Moving for a summary judgment.
Do it. Yes, there we go. Summary judgment.
I don't believe that the state has met its burden in proving its case, and
granted,
I
believe this case should be dismissed.
So that's a motion for a directed verdict.
Yes, Your Honor.
All right, would you go ahead and elaborate on that then, and then I'll ask for Mr. Weston's response.
Yes, Your Honor. The state presented testimony from Deputy Warnock, and I heard no testimony regarding any restricted actions pertaining to Miss Pardee. In fact, and in addition, the videos that the state has provided are simply two pictures of a fence. I don't believe that two pictures of a fence without any, I don't believe that these two pictures of a fence meet any of the restricted actions that are contained in Section C of the anti-harassment order. As I elicited from the officer during his testimony, these restrictions are placed upon a person and are restrictions regarding the protected person. The anti-harassment order is not based on protecting a fence. The anti-harassment order is based on actions of harassment, following a person, monitoring a person, keeping a person under physical surveillance, and so on and so on. I don't believe that either the state's witness of Deputy Warnock or the state's witness of Mr. Ayden has shown any specific actions of Miss Pardee that would give a legal basis as to a court or a jury finding a violation of an anti-harassment order based on these two pictures alone. Therefore, I am asking that the court dismiss this case.
Mr. Weston?
Your Honor, I think there is sufficient evidence to prove this case beyond a reasonable doubt. The deputy testified that there are two videos that were posted from the defendant's Facebook page, posted on the concerned community's Facebook page for the whole community to see. And the videos were pointed directly at the defendant's fence. There's no reason other than the fact that the defendant here was monitoring, keeping under electronic surveillance, using a phone, video to record or even photograph the defendant here. Just because the defendant didn't actually record Mr. Ayden himself should be irrelevant. The fact is that she was monitoring the defendant's property where Mr. Ayden resides from her front yard with a cell phone. This wasn't a Ring camera or surveillance video. She took her phone out, raised her phone up, took a video and posted it on Facebook. The state believes that this shows that she did more than just take a photo of a road or do anything of that sort. It shows that she intentionally recorded the victim's fence and property to monitor, harass, to electronically survey the victim in this case. And the state believes that there's sufficient evidence for the jury to find that she did.
Last word, Ms. Rao.
I'll defer to the court.
Obviously, we're talking about Section C and the restraint provisions of the order. The conduct that is at issue here, I think, is encompassed by the notion of following, monitoring, or keeping under physical or electronic surveillance. Specifically, this restraint provision prohibits the use of phone, video, or audio or other electronic means to record, photograph, or track a location. If somebody is monitoring another person, it's reasonable that they will spend a period of time watching them or their property in order to know where that person is or to keep track of their comings or goings. And during that time, the majority of that time, they won't actually be observing the person, especially if they're in their house or waiting for that person to return to their house. But the concept of monitoring, keeping under surveillance, or using a phone to track locations encompasses the conduct that's displayed here. It's the only question I have is when did that conduct occur? We have evidence of when it was posted onto that Facebook page. The deputy testified pretty clearly about when that video, those short video clips appeared on that Facebook page. But what we don't know, at least that I may have missed it,
we don't
is
have
when
that.
the conduct occurred to record that, the videos that were ultimately placed on the Facebook page. And I guess I would invite you to comment on that, Mr. Weston. Do you know when either of those videos were recorded based on the testimony that we heard today?
It's based on, it's the state's understanding that when these videos are live, they're posted on Facebook live. They're happening in real time, real life. They're not videos that are taken with the phone and posted later. And so the state believe that the time on the videos is when the time was.
So the time stamp that the deputy testified
is when the videos were taken.
When he said 4 days ago, meaning he was watching it on September 12th, 4 days ago means September 8th is when it was recorded.
Correct, Your Honor. And then the September 9th one is based on the timestamp, happened on September 9th, 2024, which said 3 days ago, which corroborates the deputy investigating on September 12th.
All right, understood. I may have just missed that part or not fully understood exactly what he meant when he said that. All right, Ms. Rowe, then I think based on what I said here about the nature of what what following, monitoring, keeping under surveillance, or using a phone to track locations means, that conduct is encompassed within, or that prohibition encompasses the conduct that was proved here or demonstrated with evidence here. So I'll deny your motion for a directed verdict.
All right, so it's going to go to the jury.
Right, let's turn to the jury instructions. The only jury instruction that the state proposed that I think needs to be removed and not given is the one regarding expert witnesses.
Yeah, no objection to that, Your Honor. I saw that after I filed it and figured we just kind of take it out after we went through them.
So that's another instructions 1-5. That one. Do you have any objections to any of the instructions that the state is proposing, other than the one about the expert witness, which I'm going to?
No, I don't believe I have any objection to the rest of them.
I'm going to number these and have them copied and give them to the jury.
Is it possible that I get a copy of those as well, Your Honor?
Each of you is going to get a copy.
I don't know if I would consider filming something for 3 seconds to be surveilling. Surveillance generally implies a longer period of monitoring. But we're in the Pacific Northwest, and terms mean different things to different people. So the judge who was up from that area, Thurston County, might see things differently. Bring the jury. It takes more time to copy this than it does to read the instructions to the jury.
Table where you left it.
And Your Honor, I guess I would like to address the court on one last issue.
Okay, go ahead.
Amber, you're on live.
Your Honor,
Hang on.
Respectfully understand, although I disagree with the court's ruling, but what I would ask the court is that the state not basically adopt this court's recitation of its conclusion as to the motion that I just put forth. I'm asking that the state not be able to use the court's wording that the conduct of issue, what the conduct of issue is here, that the concept of monitoring encompasses the conduct at issue here. So
Amber,
that would be my request, that the state is not allowed to basically use the court's ruling in the motion to dismiss in its closing argument.
Okay, I mean, I think I understand what you're saying. What I was ruling on was whether the facts that we heard were legally sufficient in meeting the definitions that were put forth in the restraint provisions of the order. And obviously, no one can argue conclusory, the legal issues to the jury. Factual issues, yes, certainly.
But not the legal
I know what you mean. Because the way I put that made it sound like it's a legal conclusion that must be come to if certain facts are present, which of course the jury is not bound to find those facts. Yeah, I think I know what you mean, Mr. I hope that makes some amount of sense, Mr. West.
Somewhat, Your Honor.
Do we need to go into it more?
Yeah. What exactly am I?
Well,
she asked me
the motion was for a directed verdict,
right?
Which is based on the notion that the fact presented in court and any reasonable inferences from those facts, no jury could conclude beyond a reasonable doubt that the statute or the restraint provision was violated. That was the argument, and the ruling was to deny that, and then the reasoning for the ruling was that the facts as presented encompass the act of monitoring, keeping under surveillance, using a cell phone, and so forth. But what that really means is the jury could find those facts are sufficient, not that they must.
Right. But I can still argue that based on everything you hear, it was, the defendant was monitoring.
Sure.
Yeah.
You're going to have to because that's the actual restraint.
Right. Okay. I'm just clarifying that because that's all. Thank you.
No, that's not to say you can't argue those things.
Oh, that was weird. Plugged in my phone. I got like ocean noises.
So here's the cover page. So go right into instructions and closing.
So if I could, Your Honor, I'm sorry, I'm wrestling with this. I have to do my job. I am asking that the court, that the state not state that the concept of monitoring encompasses the conduct displayed here. I believe that's a legal conclusion, and that is a conclusion that the jury in its deliberation has to come to the agreement of.
Well,
so I guess what
he can argue, Mr. Weston can argue that they can find those facts and come to that conclusion, but not that they must. I mean, I think that's the difference. There's no mandatory finding of fact. That these are facts that are just put into the trial, but the jury is free to reject those facts. And even if they accept them, they may also not be willing to conclude that they violate the restraint provision.
Okay.
It would be impermissible to argue to them they must.
Yeah, I guess the way it's worded from the court sounded like a legal conclusion, and I just didn't. Right.
We're in Thurston County, Washington, Pacific Northwest. Holiday Inn Express
Just
courtroom.
real quick, Your Honor, are we doing an opening statement before or after lunch?
We already did opening statements. We're on
Okay.
closings. Well, apparently we're going to lunch. We might never know how this one ends. I think we're going to go to lunch. It's time. I realize there is a verdict that is coming in, and let's see. In the Lori Vallow case, let's see. Is Katia covering this one? Hang on a second. Let me see if we can portal over to get the Lori Vallow verdict. Let me see who we have. Trial TV is. We'll try that. Let's see. Trial TV, Lori Daybell, verdict watch. We'll go there. All right. So here we go. We're gonna portal everyone over to Trial TV Live to watch the Lori Vallow verdict, which is going to be coming in just moments. They were the first ones I could find. I made the link. We're ready to go. I'm gonna go to lunch. I'm shaking. I've had just nothing but sugar today. I'm not sure if that's what the proper treatment for a cold, but everyone's been sending me pictures of ham sandwiches that are about this tall, and I want one now. I want one. So after lunch, I'm going to be working on the bathroom, which means we're going to be off until tomorrow morning, where we're going to pick up with closing arguments in the Karen Reed trial, which is going to be amazing. Also, we get. Sorry, not proper treatment. I'm sorry. Water Troy. Can't wait tomorrow we'll see if we can get a closing for whatever happened in this small case. But podcast. Oh yeah, podcast tonight, 8 p.m. That we're going to be here tonight, so we'll be here for that, and then after that we're going to be live with the other one. So don't miss the podcast. It's going to be fun. Please join us, and of course we've got some fun things. I'm going to possibly ride the e-bike for a little bit with the kids today as well. After the bathroom's done, that's first priority. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe. We'll live again tonight, 8 p.m. at the podcast. Other than that, we're going to see you over at Trial TV Live with a verdict here in just a moment. So, it's been a rough day. All right, have a good one. We'll see you in a little bit. Bye-bye.